Good morning, everyone. Welcome to It's a Crime. For those of you who don't know me, my name is Linda, and today is Chad Daybell's trial, day 25. And supposedly today we'll be finished with the prosecution. They will rest. We will see what happens and how long it's going to be. The judge estimates it's going to be a short day. So it's been a long journey with a lot of information, a lot of disturbing information. I just did a video this morning. I recorded it. I didn't put it up yet. I still have to edit it, but it's done. So you can look forward to that. Yesterday was a bombshell with Chad and Lori's coded phone call the day before the children were found in the yard. So that was a little crazy. It was a half an hour long, I believe they played, around a half an hour. And I need to dive into it. So that'll be next. So welcome everybody who is joining. We'll see what happens today. Thank you, Pearl, gifting It's a Crime membership.
Thank you. Good morning. Our jurors are lined up, so we'll go ahead and have them brought in if everybody would remain standing.
Wow, they're
please.
on it today. They are on it. We'll see what happens. Notable, John said rigor mortis the other day. Oh, John. Oh, we got matching murderous ties, or just one murderous tie today? I think one. Lindsay's bringing it today. I'm matching Lindsay just a light color.
Thank you. Please be seated. All right. Good morning, everyone. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're continuing with evidence on the state's case in chief. The court notes the jurors have all returned, and I've received the juror affirmation from each one of the jurors that they've followed the court's admonishing instruction as we broke for the day yesterday. So thank you again to each of you for following that instruction. At this time, then, I believe the state is prepared to call its next witness. Is the state ready to proceed with a witness?
Yes, Your Honor.
Who will that be?
Doug Hart.
Very well. You can call your witness, Ms. Blake.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's just right into your kid. All right, before we get started with direct examination, then would I refer to you as Agent Hart?
That's fine, Judge.
Agent Hart, with the court's exclusionary order here, I'm going to ask, because this case has been live streamed as well as open to the public, have you watched any of the trial testimony that's taken place?
No, I have not.
Have you talked to anyone else about testimony they've provided?
No.
All right, thank you. Ms. Blake, you can inquire on your direct.
Thank you. Agent Hart, can you remind the jurors where you currently work?
At the present time, I'm the chief deputy for the Canyon County Sheriff's Office.
And where did you work before that?
Prior to that, I was an FBI agent for 27 years.
And when you were with the FBI, did you become involved in a case involving some missing children named Tylee Ryan and JJ Vallow?
Yes, I did.
Did you personally assist in that case or work on that case?
Yes, I've worked on the case since its inception in November of 2018. Or 19, excuse me.
And can you explain why the FBI came to be involved in that particular case?
Yes, it's a very common occurrence for the FBI to be asked to assist in cases involving missing children. Of course, when those cases come to us at the onset of the case, we don't know what has happened. There could be elements of those cases.
Judge, I'm going to object at this point. This has become a narrative.
Overruled.
There could be elements of those cases that would, at a future date, indicate a federal prosecution. And so we're brought in early to assist our city and county partners, and that assistance continues through the entirety of the investigation.
Prior to being involved in this case, had you worked on cases involving missing children?
Several.
With regard to this case, did the FBI follow up on leads?
Yes, there were a tremendous number of tips and leads that were received during the course of this investigation. Those leads that involved information out of the state of Idaho were primarily handled by the FBI, and those tips and leads that were within the state were generally handled by the Rexburg Police Department or the Fremont County Sheriff's Office.
In this case, let me back up. Is it common in a case with missing children to look at the parents?
You look everywhere. You cannot have blinders on as a case develops. You have to follow the evidence and follow all of the investigative measures and leads that exist. And that's the process. Sometimes parents are involved, but you don't automatically look to any one individual at the onset of a case.
And is that in fact how the investigation proceeded in this case?
Yes.
Are you aware if other specialists or other branches, I may be using the wrong term, other areas of expertise within the FBI became involved in this investigation?
Absolutely, several did. The FBI possesses individuals and units that have particular skill sets that oftentimes can't be replicated due to resources by a city police department or a county sheriff's office. And so in this case, we had forensic accountants, we had electronic cellular telephone specialists, we had the FBI lab, we had our evidence response team, we had analysts, so on and so forth. Each of those individuals or units have a particular expertise and skill set that were brought to bear in this case as our needs dictated.
And Your Honor, I'm going to ask if I can be handed State's Exhibit 170.
Very well.
Agent Hart, as part of your work with the FBI, did you work on reservations?
I did. I have spent approximately 14 years of my career, either full-time or part-time on various different Indian reservations.
And with that, did you deal with any kind of burial sites?
Yes, when you're assigned to an Indian reservation, There are specific trainings that you go through in preparation for the types of cases that you might see. One of those trainings is the identification of clandestine grave sites, as well as how to process and exhume clandestine graves.
We talked about you being involved in the search for some missing children. Were you also involved in recovering their remains?
I was present on June 9th and June 10th of 2020 for the search warrant that was executed at Chad Daybell's property, where we located the remains of JJ and Tylee.
Your Honor, I'm going to ask to be allowed to publish States Exhibit 170C, D, E, and H,
All right, can
one
you,
at a time.
with Exhibit 170, what does that entail in total?
The Exhibit 170 runs from 170A to 170U. And then there are some additional portions of it. The packet or the portion that I'm focusing on deal with images taken from the body recovery site.
Okay, and that's an admitted exhibit, correct?
It is.
Okay. Thank you for the clarification there. So you've requested 170 C, D, and H.
E and H.
Okay, those may be published.
Thank you. And Agent Hart, I believe there may be a pointer up there if it's helpful with your testimony.
Got it.
And for the record, I'm currently publishing C. Agent Hart, can you tell us if there's anything within this image that you noticed when you were on scene?
Yes, I think there's some better photographs, but this is a photograph of the location of JJ's burial, which you can see kind of in this area.
And I'll move now to States Exhibit 170D. And when you said there were some photos showing it a little bit better, is this one of those?
Yes, this demonstrates what we look for when we're searching for a clandestine grave site. One of the telltale signs is a change in the plant growth that's fairly distinctive. So you can see consistency all around, but in this rectangular area here, you have a different color of plants, as well as just some lack of growth. And so as you look, you can see a fairly distinctive area here. And this is what I observed as we were doing our initial survey of the property.
And now publishing 170E. Does that show anything additional?
It's just a closer demonstration of the a pretty specific line, and as we felt in the dirt, you could actually feel a seam where the sod had been taken up. And again, just an indication that that may be an area where digging has taken place, which proved to be true.
And when you talk about you can actually feel, do you mean with your hand?
Yes.
And now publishing 170H. And do you recall what is in this image?
Yes, as we were walking the property, we have probing sticks, and that's a way to push a rod into the earth. On that spot where we've shown the different growth, I couldn't penetrate that area with a probing rod. And as we took up the first layer of sod, we found a board and rocks, which is what I was hitting with the rod as I was attempting to probe that site.
And again, that's something that you had done previously in your career?
Yes, I've had specific training for that. And prior to that time, I had personally been involved in search warrants with the exhumation of burial sites.
And once those things were removed, what was found underneath those?
JJ's body.
After the recovery of the children's bodies, at any point, did you attempt to speak with the Daybell children?
Yes, myself and another agent went over to their residence, which is kitty corner to the Daybell property, on the evening of June 9th, and spoke with them at length about what was taking place.
Was it your understanding initially that they would agree to speak with you?
That's the request that I made to them. We explained that we had some things that we wanted to tell them and talk with them about, and asked if they would sit down and meet with us.
At some point, did they decline to meet with you?
Initially, they agreed to meet with us. And then the following day declined to keep that appointment after speaking with Chad Daybell.
Judge, I'm going to object at this point. There's no foundation to suggest that information. I'm going to move to strike.
It's overruled.
Agent Hart, as part of the investigation, and I think we've talked about this before, but did you review some iCloud data?
I spent well over 100 hours reviewing iCloud data, yes.
Do you recall what iCloud accounts those were?
There are two. There's one entitled Lori for Style at iCloud.com, and the second is called Lolly Time at iCloud.com.
And who were those accounts ultimately associated with?
Both of those accounts were registered to or subscribed to Lori Vallow.
And in going through those, was that a significant amount of information?
It's a tremendous amount of information, tens of thousands of text messages, multimedia messages, voicemails, thousands upon thousands of photographs, videos, emails, everything that you would find on a modern smartphone. The iCloud is simply a cloud storage device for all of that content.
And in preparation for your testimony today, did you prepare an exhibit?
Yes,
Do you believe that exhibit would assist you in testifying today?
it would.
Do you believe the exhibit would assist the jurors in understanding your testimony?
I do.
Your Honor, I'm going to hand to the court what's been marked as Exhibit 183B. I will note there are printouts of a PowerPoint. The PowerPoint or the exhibit itself is actually contained within Jump Drive.
All right.
And with the printout, I do have a courtesy copy for Your Honor as well as counsel, and one for the court.
Thank you.
And if I may have the witness handed a copy of 183B, the printout.
And Judge, could we have a sidebar, please?
Yes.
Judge, can we have a sidebar? Because I'm freaking out right now. Today's the last day. The prosecution's going to rest. This isn't looking good for my client. So, did you guys hear that? That the children were asked by the authorities to talk to them on June 9th, which is the day the children were found and the day Chad was in the back of the cop car confessing. Where are you going? Well, help yourself, Chad. This is going to be the last coffee you're ever going to have properly in a courtroom or anywhere in public. I love that the two, because he's a fleer. Did you notice that the sheriffs are like, they got up. They're like, what's he doing? That's the first time I've seen him stand, maybe because I've just been taking notes, but he stood to go get it and everybody just kind of stood up because he's a fleer. Anyway, so the children were supposed to talk and then they didn't. Now remember, I don't know if you saw my video, I broke down the cop car cam footage and talked about how he mentioned, well, Chad tells Emma, well, cooperate as much as you like, which I found that an interesting wording. Daybell children keep secrets. Remember that? The children are good at keeping secrets. This is going to be very interesting. You got to get the popcorn out this week because it's going to be very interesting. I guess next week. We'll see if they start tomorrow or if they start Monday with John.
All right, thank you, Council.
John-
Based on that sidebar, there's a evidentiary ruling the court is going to need to take up on the record, but outside the presence of the jurors. I think this will be a quick argument in lieu of a break here. If we could just have the jurors line up in the hall, please. And we'll go on the record with the objection. Once the objection's resolved, the jurors will come right back in.
All right, wait.
This is water. I know. It's a slip. It's okay. I have to think quick. Maybe not quick enough this morning. We gotta say, it doesn't matter. I could say it's Kool-Aid.
All right, thank you. Please be seated.
I gotta check what he's eating.
We're outside in the courtroom, the jurors have been excused for hearing on an evidentiary objection. The state's proposed Exhibit 183B. Defense has an objection at this point, and I found it's proper to take it up outside the jurors' presence so that any reference to what may not come in would not be heard by them. So, Ms. Blake, perhaps if you give additional foundation of what the proposed exhibit is, and then I'll hear any objection from the defense.
Yes, Your Honor. The exhibit is content from the iCloud accounts associated with Lori Vallow, that Lori for Styles and Lolly Time. Both of those are stipulated to exhibits, meaning the entire content has been stipulated to come in. This particular proposed exhibit is excerpts directly from those accounts, I believe mainly from the Lolly Time account. This was turned over to defense counsel at the end of January as a proposed exhibit. There was a few modifications made and the modified version was provided to counsel. However, the modifications made included removing 3 slides in their entirety. There were no other additions or changes made at all to the exhibit. So given that, that's just what the exhibit is.
All right, thank you, Ms. Blake. Mr. Pryor, is there an objection from the defense?
Judge, the objection is not the admission of the exhibit. The objection is that counsel throughout this trial has had a repeated course of action of providing me summaries either late the night before the testimony is to incur or the morning of or late in the evening on the day before. I'm not objecting to the admission of the emails from Lolly Time. In fact, that was a stipulation of the parties that those be admitted. What I am asking for is an opportunity to ensure that what Ms. Blake is representing doesn't contain anything outside of what was stipulated to. And the fact that I got an email, I believe it was last night or the night before, that there were modifications made to this. I want to ensure that those modifications are as they were represented, and I ought to be afforded that opportunity.
All right, Ms. Blake, to be clear then, the modifications were taking things out of the proposed exhibit, not adding things in. Is that correct?
Correct. None of the remaining slides have been modified or altered in any manner from what was turned over in January. The only modifications were the removal of 3 slides.
Okay, well, considered the objection here then. First, expressly was indicated there's not an objection to the admission of the exhibit. So with that and it being offered, the court will admit Exhibit 183B. In terms of the timing, while I understand it's certainly difficult in the middle of trial to be dealing with any modifications because this involved the taking out of some information, not adding it in, I think the court could presume that defense counsel has had an opportunity to review that. So I'll have it now that it's admitted. It may be published. However, if during the course of publishing you see something that doesn't seem to comport with your understanding of the exhibit, Mr. Pryor, you are allowed to make an objection, and I would ask the state be ready to stop publishing on quick notice if an objection comes up.
The state has no problem with that, Your Honor.
Okay, thank you. And I'll note also then this would be a summary exhibit under Rule 1006. Is that how the state's offering it?
Yes, Your Honor.
Okay, well, the exhibit's admitted then, and with the objection resolved, we'll have the jurors return for additional evidence.
Yes, Your Honor.
My third eye is rolling all the way to Idaho this morning.
All right, please. Raise all President counter for Your Honor.
Thank you. Please be seated. All right, we're back on the record after resolving that evidentiary issue. The court notes that Exhibit 183B has been admitted, and you can continue with direct, Ms. Blake.
Thank you, Your Honor. The state would request to publish 183B.
You may publish.
I believe the court has the original jump drive if you'd like me to publish from that.
All right, we'll get that submitted.
Agent Hart, does this appear to in fact be the exhibit created by you?
It is.
And Your Honor, I'm going to pause here to allow the jurors to read.
Very well.
Text from Lori to Alex. I'm finding out some great stuff about you. I'm going to do some ceilings. Can't wait to share all the things I learned about you. Kiss emoji, heart emoji, heart emoji. Wow, you're going to like it. It'll explain a lot. Alex to Lori. Okay, hurry up, please. Lori to Alex. going to check everything with my source tonight to make sure I got this all right, but it's really good. We can talk about it tomorrow, hopefully. Heart emoji, heart emoji.
And Agent Hart, can you indicate who these messages were being sent from and who these messages were being sent between?
These are messages between Lori Vallow and her brother, Alex Cox.
And can you read the date of these messages into the record?
These three messages are from March 20th of 2019.
When we look at these particular messages, what about them caught your attention?
Alex Cox was a figure during the course of our investigation, and what caught my attention about this particular interaction between Lori Vallow and Alex Cox is in line 1837, that Lori Vallow had to check everything with her quote source to make sure she had her information correct, but that it was really good.
Did this indicate to you that Lori herself didn't have this information?
Yes, that's why I think it's significant.
And did you also see in here that Lori was then going to pass that information on to Alex?
Yes,
Did you learn through the investigation who Lori's source was?
Foundation.
Sustained.
Through the investigation, did you see messages from Lori to Chad quite frequently?
very frequently.
In those messages, was she oftentimes requesting information?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lindsay reads really fast, so I got to do it fast. Okay. Chad to Lori. I've been instructed to focus my efforts on Hillary, so I will. Kiss emoji. Lori to Chad. Okay, find out her percentage for me and JJ's. So he's talking about Tylee. Chad to Lori. She is at 0.13. I turned up the pain to 10, placed a spiritual virus in her. He is at a 99.99. Raphael visited him and told him to follow Amy into the light. I also assured him that James would love and take care of his mommy, which he will with all of his heart and soul. Lori to Chad. That is sweet. I miss you desperately. Oh my God. That's messed up.
And Agent Hart, would you indicate the date these were sent into the record?
Yes. These four text messages were sent on July 18th of 2019.
What had happened 7 days prior to these messages?
Lori Vallow's husband, Charles Vallow, had been shot and killed.
Through your investigation, did you learn who Hillary was a reference to?
Yes.
And who was that?
Tylee.
And there's also a name in here, Raphael. Did you learn who Raphael referred to?
Raphael is a name, another name used by Chad Daybell between he and Lori Vallow very frequently throughout the course of their communications.
And also a name, James. Do you know who that referred to?
Yes, that is another name for Chad Daybell, as referenced in the James and Elena communications between Lori Vallow and Chad Daybell.
And did you learn who Amy was in reference to?
I did not, could not find out specifically who Amy was.
What about this series of messages stood out to you?
There were three very critical components to these messages.
Can we go through them one by one, please?
Yes.
What was the first one?
The first is line 2667. This is a text that is initiated by Chad Daybell to Lori Vallow, indicating that he has been instructed to focus his efforts on Tylee Ryan.
And what was the second thing that stood out to you?
The second thing is present in the following two lines, 2665 and 2660. Lori Vallow makes a reference to Chad Daybell or a request to find out her, meaning Tylee Ryan's percentage, as well as JJ's percentage. That word is referring to the death percentage for Tylee Ryan and JJ.
Judge, I'm going to object. Calls for speculation. Move to strike.
Overruled.
In fact, in subsequent texts, the
Judge,
exact,
I'm going to object at this point. Non-responsive. There hasn't been a question.
Sustained.
Agent Hart, you were explaining why those lines stood out to you. Could you please continue your explanation?
the words death percentage are used in subsequent texts. This series of text messages is the first in a series of texts that will take place over the next 3 weeks between Lori Vallow and Chad Daybell. In those text messages, in varying degrees of detail, they refer to the death percentages of Tylee, JJ, and Tammy. Those text messages over that course of 3 weeks.
Judge, I'm going to object at this point. It's again becoming a narrative.
Sustained.
And what course of time or what period of time did those messages cover?
Approximately 3 weeks.
And when we look at that line 2660, there is reference to specific percentages, it appears.
Yes.
Could you talk about that a little bit?
Again, this is a message from Chad Daybell to Lori Vallow wherein he is indicating his death percentages for Tylee at 0.13 and for JJ at 99.99, which follows with a reference that Raphael or Chad Daybell had visited JJ and told JJ to follow Amy into the light, which is a common reference for death.
In this particular message, there's also a reference to turning up the pain to 10. Who said that again?
Chad Daybell.
And also a reference to placing a spiritual virus in her. Who said that?
Chad Daybell.
And then in that last sentence, did anything about that stand out to you?
Well, line 2660 is a specific conversation regarding the deaths of Lori's children.
Judge, I'm going to object. That's calling for speculation in the conclusion, and I'm going to move to strike.
I'll sustain the objection and strike the response.
Based on your investigation, your experience and review of these messages, what did you believe line 2660 to be referencing?
It's referencing their death percentages,
And who are they?
Tylee and JJ.
And what is Lori's response to that, to the talk of death percentages of her children?
That it's sweet and she misses Chad Daybell desperately.
Was this the first time in these messages that you had seen reference to these death percentages that you can recall?
Yes, this is the first message, and there are several that follow in the next 3 weeks, and then later on there are additional similar conversations regarding Tammy.
Were there additional messages on July 18th of 2019?
Yes, this conversation continues for the next couple of slides.
And moving to the next slide, I'm going to pause to allow the jurors to read.
July 18th, Chad to Lori. You are so adorable, beautiful, wonderful, heavenly, luscious, and angelic. So many divine attributes rolled into one dynamic, desirable package. I want you even more desperately than you want me. Kiss emoji, kiss emoji. And then about a half an hour later, Chad to Lori, just grab me by the storm and I will follow you to the ends of the universe. Fire emoji, fire emoji. Lori to Chad, when might that be? And Chad to Lori, Wednesday evening, and then repeatedly and gloriously until
And
Friday.
Agent Hart, you indicated these are a continuation from the messages on the previous slide. Is that correct?
Yes.
What about these particular messages stood out to you?
Primarily lines 26, 22, 2608, and 2607.
Through the investigation, did you become familiar with what has been referred to as the James and Elena story?
Yes.
Did you become familiar with some of the texts that appeared to be a reference or continuation of that story as well?
Yes.
And do you know were you familiar with the term storm?
I am.
And did you know what that was in reference to?
Yes.
And what was that?
That's Chad Daybell's penis.
And Chad's texting to Lori to grab him by his storm and he'll
Judge, I'm
follow
going to
her
object
anywhere?
at this point. It's somewhat leading. And I think the
Sustain on leading.
Oh, it's leading, all right.
What else about that series of three messages caught your attention?
Well, throughout Chad Daybell and Lori Vallow's relationship, Lori is pushing Chad Daybell. And so I included these to show Lori Vallow questioning. Chad Daybell remarks that he'll follow her to the end of the universe. And her response is when? When might that be? Chad's response is in reference to a planned trip that he would take the following week, July 24th through July 26th of 2019, to be together with Lori Vallow. That's the reference to Wednesday evening to Friday. But we see Lori Vallow pushing Chad Daybell as it relates to their relationship.
So it would be Chad and Lori were going to be together physically or at the same time.
Yes, Chad Daybell traveled to be with Lori Vallow for a period of 2.5 days.
And again, during this time, was Tammy Daybell still alive?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Do we really want to move on? Lori to Chad, and then what? Lori to Chad again, back to crying and saying goodbye, back to the box, question mark. Chad to Lori, this trip to Utah had a lot of finality to it. I was told extreme changes are coming for me and to Utah. I welcome them both. I said good day, sir.
And Agent Hart, I believe you indicated these are a continuation as well from the previous two slides.
They are.
What was it about these messages that caught your attention?
Primarily, there was two things.
And can we go through them one by one?
Sure.
What was the first thing?
The first is again, we see Lori Vallow manipulating Chad Daybell. In the prior slide, Chad Daybell had indicated that they would have this time together Wednesday through Friday. And Lori Vallow's response to that is, then what? And she then says, back to crying and saying goodbye back to the box as a reference to being trapped with their inability to be together.
And at this point in time, Charles Vallow has been killed,
This is 1 week following his death.
but Tammy's still alive.
Correct.
And what was the second thing?
The second thing is line 2603, which is Chad Daybell's response to her. And he references that extreme changes are coming for him, and he welcomes those changes.
And do you recall from previous testimony references Chad also made about feeling trapped?
Judge, I'm going to object. It's leading.
Overruled.
Yes,
And do you recall approximately, or do you recall what those statements were, what that was in reference to?
yes, that conversation took place at the conclusion of this trip that they're talking about. So that would have been on July 26th of 2019, where Chad Daybell references the Harry Potter stories and feeling trapped, having to live under a stairwell, and he gets to escape occasionally to have adventures with his goddess lover.
And when you look at that line 2603, there's a reference to extreme changes. Did that catch your attention?
It did.
What did you, through your investigation and experience, what did you believe that to be in reference to?
Judge, calling for speculation. Objection.
Overruled.
Well, within 3 months of this date, Tylee, JJ, and Tammy are all dead.
Moving to the next slide, I'm going to pause to allow the jurors to read.
God, here we go. Okay. July 20th, Lori to Chad. What's Blake's percentage? Lori to Chad, again, same time. He drew 3 crosses on the wall in his bedroom. We just finished painting over them. She says, like he was marking it for the dark side to find him. And then Chad says, Blake is at 7. I took my sword of light and sliced his aura vertically in several places. You should be able to now rip and burn it. Chad says, I also decreased his pain tolerance to 1% and greatly increased his pain. His desire to depart is at 80%. This is Melanie Pulowski's children.
And Agent Hart, can you indicate the date these messages were exchanged into the record?
Yes, this is July 20th of 2019.
And who are these messages between?
Lori Vallow and Chad Daybell.
There's an individual reference named Blake. Did you learn who that was?
Blake is Melanie Boudreau's son.
Do you know his approximate age?
3 to 4 years old at the time of this message.
What about these messages caught your attention?
There were 2 things primarily that caught my attention in this series of communications.
What was the first one?
The first is, again, Lori Vallow is petitioning Chad Daybell to find out Blake's percentage. So repeatedly, we see Lori Vallow asking Chad Daybell to provide that information. Chad Daybell is the source of the death percentages.
What was the second thing?
The second thing is that this is a conversation about a 3 or 4-year-old child. And in line 2481, Chad Daybell writes that he decreased that child's pain tolerance to 1% and greatly increased his pain.
And do you recall in one of the previous slides in reference to Tylee Ryan, Chad talking about turning up or causing her pain?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lori to Chad, good morning. Missing you. Didn't sleep much. Need you to check JJ. Weird stuff happened in the middle of the night. It's like they distracted us with Blake. Kiss emoji. Lori to Chad, when you get home, check Tylee. She's being super sweet and helpful, and she cleaned her room. She got switched. Totally not her. Heart emoji. Lori to Chad, see if she got switched. Chad says, yes, she was switched. Please let me know when you can talk and I will explain it. Oh my God, yeah, I'll make up more manipulations for you, Lori. That's from Linda. Just Linda.
And Agent Hart, can you indicate the date these messages were exchanged into the record?
July 23rd of 2019.
And who were these messages between?
Lori Vallow and Chad Daybell.
What about these messages caught your attention?
Again, two things primarily caught my attention.
And what was the first thing?
The first is if we look at the time of these messages, there's an 11-hour gap between line 2276 and 2244. In line 2276, Lori Vallow petitions Chad Daybell to check JJ. In the subsequent line, 11 hours later, she's asking Chad Daybell to check Tylee to see if Tylee has been, quote, switched. And so these messages are 5 days after the initial first message that I ever located regarding death percentages. And so this is now the second time that I could find in the review of the iCloud where Lori Vallow is asking Chad Daybell specifically to check on JJ and then to check on Tylee. So that's the first thing that stood out to me.
And Charles Vallow had been killed not long before these messages.
12 days prior.
What was the second thing that stood out to you?
The second thing that stood out to me is in line 2241, which is Chad Daybell's response to her. And he replies that, yes, Tylee has been switched. And he says, let me know when you can talk and I will explain it. So Chad Daybell is the one who will explain to
Judge,
Lori
I'm going to
Vallow.
object at this point. Speculation.
And what was the last part of that answer?
Lori Vallow is making inquiries to Chad Daybell, and Chad Daybell tells her, I will explain it.
Prior to Charles being killed, are you aware if he was deemed to have been possessed?
He was.
And ultimately he was killed.
He was.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, how are things at home? Lori says, she's fine. Need you to check JJ. She said he was calm and he watched movies all day, which he would never do. Lori to Chad, missing you, kiss emoji, kiss emoji.
And Agent Hart, can you read the date of these messages into the record?
July 26th.
Yes, July 26th of 2019.
So this is just 3 days after those last messages we looked at?
Correct.
What about these messages caught your attention?
That the pattern of Lori Vallow asking Chad Daybell to check is continuing. So on line 2119, Lori Vallow writes, "Need you to check JJ," and references his behavior, which was a departure from what was normal for him.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, missing you too. It is still JJ. I'm told she is lying about him being calm and watching movies. Lori says, Mel knew. She called me. She felt the real Brighton last night and knew she was different. She was told I didn't want to tell her. She is taking well and knowing it is part of a big plan. She is amazing. Kiss emoji. Although I'm still pretty upset over it. I love you, heart emoji, trying to hang in there, quote unquote, missing your kisses, kiss emoji. So Brighton is also Melanie Pulowski / Boudreau's child, and Brandon.
And Agent Hart, can you read into the record the date these messages were exchanged?
These messages were also, as with the previous slide, on July 26th, 2019.
What about these particular messages stood out to you?
Well, in response to the previous slides, request by Lori Vallow to Chad Daybell to check JJ, Chad Daybell replies that essentially JJ is still his true self, but he indicates whoever told Lori Vallow that JJ was calm and watching movies had been lying. So Chad Daybell answers Lori Vallow's inquiry regarding checking JJ.
And looking to that next message, are you aware who Brighton is?
Yes,
And who is that?
Brighton is another of Melanie Boudreau's children.
And the name Mel there, do you know who that was referencing?
That's Melanie Boudreau.
Was there anything about that next message that caught your attention?
This next message is somewhat vague, but we see a reference to a big plan, which is a word that we see repeatedly in conversations between Lori Vallow and Chad Daybell referencing their plans.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, one question. Do you want me to cause pain yet to those 2 3s you're riding with? Lori says, probably hold off on them till we arrive. They will be mistake to deal with. But I'll text you if they start acting up and we can zap them. Lori says, miserable, not mistake. So she made a mistake saying they will be miserable to deal with. Chad says, sounds great. Yes, if they're going to act up, we'll at least give them a reason to scream. I love, cherish, treasure, and adore you. The wonderful memories just keep coming back. You are mesmerizing. Raphael is one lucky guy. And you're one big bastard, said by Linda.
And Agent Hart, can you read the date of these messages into the record?
Yes, these 4 messages were exchanged on July 29th of 2019.
Who were the messages being exchanged between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
At this particular time in the investigation, Lori Vallow Melanie Boudreau and their children, as well as Alex Cox, had decided to take a trip to the California coast. And so these messages were sent to Lori Vallow as they were driving in the car, as Lori Vallow, Melanie Boudreau, Alex Cox, and the children were driving to California. And so Chad Daybell makes an offer to Lori Vallow to cause pain to the two, quote, threes that she was riding with.
And looking at that, at the line 1872, did any of that catch your attention?
Of course. In line 1877, the two threes are referencing two of the children that are in the car with them. And in line 1872, Chad Daybell indicates that he would at least give them a reason to scream, indicating a supposed ability to cause physical pain to those children.
After offering to cause physical pain to the children, what were the next things he said?
He told Lori that he loved, cherished, treasured, and adored her. The wonderful memories just keep coming back. She was mesmerizing, and that Raphael, which is the name for Chad Daybell, is one lucky guy.
And moving to the next slide, I'm going to pause to allow the jurors to read.
July 30th. Chad says, I got the inspiration to go back to my original death percentages that helped us track Charles, Ned, etc. Tammy is very close. Her percentage has fallen steadily since Iplos left. It is encouraging. Heart emoji, kiss emoji. Lori says, well, what is the percentage now? What about JJ's 2? Chad says, Tammy is at 3. JJ is at 2. Both are being heavily shielded to stop intruders.
And Agent Hart, would you read the date of these messages into the record?
These messages were exchanged on July 30th of 2019.
And who are these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
There were three very critical components of these messages.
Can we start with the first one?
Yes.
And what was that?
The first one is in line 1781. This is a text initiated by Chad Daybell to Lori Vallow. And you can see that Chad said he had the inspiration to go back to my original death percentages. So this is the first time that we see the full phrase of death percentage, and it is attributable to Chad Daybell by the use of the word my. And then he indicates that these death percentages helped him track Charles, which is a reference to Charles Vallow. Ned is the name of the demonic entity that was alleged to be possessing Charles Vallow. And then he indicates that Tammy is very close. Her death percentage has fallen steadily, and concludes with, it is encouraging, exclamation point.
Do you also see the reference in there to Hiplos or Iplos?
Yes,
Do you know who that's in reference to?
that's the name of a demonic entity that was supposed to have been inside of Tammy Daybell.
And you said Tammy
Um,
on Hiplos.
Yes. So it says Tammy is very close. Her percentage, meaning Tammy's percentage, has fallen steadily since Hiplos left. So that entity is now out of her.
Do you recall if Hiplos was an entity that was indicated to be associated with Charles Vallow?
Judge, I'm gonna object. That's leading.
Sustained.
Do you know who else Hiplos may have been associated with?
There was another reference to that using that same demonic entity name with Charles Vallow.
What was the second thing that stood out to you?
The second thing that stood out is this reference to Chad Daybell's death percentages that helped track Charles Vallow. Charles Vallow didn't have a heart attack or pass away in his sleep.
Judge, I'm gonna object. It's narrative.
Overruled.
He was shot and killed. And so these death percentages by Chad Daybell are not simply a reference to natural deaths.
And what was the third thing?
Well, the third thing is in lines 1779 and 1778. Lori's response to Chad is to inquire, what is the percentage now? Meaning, what is Tammy Daybell's death percentage? And then she follows that up with yet another inquiry. This would be now the third inquiry about JJ's death percentage. Chad Daybell responds, Tammy is at 3, JJ is at 2.
And based on your review and your investigation, in relation to death percentages, what was the indication the lower the number got?
Well, it's not consistent. So you have references where the lower the number, the closer to death they are. And then you have references where the higher the number, the closer they are. So in the previous communication, you saw Chad Daybell indicate that JJ was at 99.99. And he instructed JJ to follow Amy into the light. In this occasion, we've flipped and they're at the opposite end of the spectrum, saying that Tammy is at 3 and now JJ is at 2 versus the prior message. So there's a lack of consistency, but the higher the number in one case, the lower the number in another.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lori to Chad, 2 and 3%, not 0? Chad says, I will explain when we talk. Lori says, okay, kiss emoji, fire emoji, still feeling hot for you, fire emoji, fire emoji.
And Agent Hart, can you indicate the date these messages were sent into the record?
Yes, July 30th, 2019. These are a continuation from the previous slide.
And what about these messages stood out to you?
Well, first, Lori Vallow's response back to Chad Daybell after receiving his answer that I believe it was Tammy was at a 3 and JJ was at a 2. She replies 2 and 3%, not 0. So we see Lori Vallow pushing 0, meaning the time has come for those individuals to die.
Judge, objection calls for speculation. I'm gonna move to strike, Judge.
Well, the objection's not timely. I'll overrule it at this point, but Ms. Blake, I am concerned if the witness is making his own interpretations of these messages, not based on the investigation. So if you could direct the examination that way, that'll help with the objections.
And in coming to that conclusion, was that based on your experience and your review of the information?
Yes.
What else stood out about this particular message?
Line 1776, where Chad Daybell says, "I will explain when we talk," indicating he is the source of what's happening.
Was that consistent with your review of these messages?
Yes, we see that exact phrase multiple times. "I will explain."
Anything else about this particular series that stood out to you?
Well, lastly, again, we see how Lori Vallow is attempting to manipulate Chad Daybell. She concludes this conversation with, "Okay, still feeling hot for you."
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, yes, we might need to release a little steam when we talk. Fire emoji, fire emoji. Anyway, this is the chart that checks what percentage mortals are still in their body. It worked for my friend's wife who died, my neighbor, George Bush, Stan Lee, etc. I kind of forgot about it because we've been dealing with zombies and demonic entities. But this afternoon, Tammy said she felt lightheaded as if her body and spirit weren't connected. Chad says, I will update the list and figure out Brandon, Adam, and others.
And Agent Hart, can you indicate the date these were being sent into the record?
These two text messages were also on July 30th of 2019.
And who were these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
Two things.
What was the first one?
The first is a continuation to further explain Chad Daybell's death percentages. In the second sentence, he references this chart that checks what percentage mortals are still in their body, and then indicates that it worked for his friend's wife who died. And so we see just a further explanation of death percentages, and that this is talking about physical, real death, not spiritual death or some other kind of death.
Was that chart that was referenced, was a copy of it ever located?
No, we could never find the actual chart. I can't account for where it might be.
And what was the second thing that stood out to you?
Well, there are two more. The first is that he references Tammy Daybell, his wife, that she said she felt lightheaded as if her body and spirit weren't connected.
And then what was the third thing?
The third thing is in line 1773, where Chad Daybell indicates he would update the list and figure out Brandon, Adam, and others. The reference to Brandon is Brandon Boudreau, and on October 2nd of 2019.
Judge, I'm going to object at this point. This is definitely becoming a narrative.
Sustained.
Who was Brandon referencing?
Brandon Boudreau.
Do you know of something that happened in relation to Brandon Boudreau?
Yes,
What was that?
on October 2nd, 2019, an attempt was made on his life.
Are you aware of an attempt that was made on Tammy Daybell's life?
Judge, I'm going to object. Calls for speculation.
Overruled.
I am.
And when was that?
October 9th, 2019.
Moving to the next slide, I'm going to pause to allow the jurors to read.
This is incredibly difficult to read. Like, it's very blurry. I can't read it. I read Lori. Photograph of Chad Daybell by something. Look at the bubbles is on the left side.
And Agent Hart, can you indicate the date these images were sent?
These were both sent on August 7th of 2019.
Were you able to, looking at that first image there, who is that?
That is Chad Daybell.
Can you tell from the photo what type of building he may be in?
Yes, it's the lobby of an LDS, an old LDS church.
And who sent that photo?
So the photo of Chad Daybell was sent by Alex Cox to Lori Vallow with the caption, "Look at the bubbies."
Do you know what Bubbies was a reference to?
That was a word.
Judge objections, calling for speculation, no foundation.
I'll sustain that without additional foundation.
Through your investigation and review of messages, were you able to determine what Bubbies was in reference to?
Yes,
And what was that?
it's just simply a pet name that Lori had for Chad Daybell and Alex Cox or other men in her life.
And could you see the time that that message was sent?
10:48 a.m.
And turning to the next image, who are we seeing in that photo?
That's a photograph of Alex Cox.
Does that appear to be in the same location?
Yes,
And what time was that message sent?
1 minute prior on 10:47 a.m.
Who sent that message?
Chad Daybell,
And who did he send it to?
Lori Vallow.
What was the caption that Chad included?
Two exalted beings.
Was Tammy Daybell still alive on August 7th of 2019?
Yes,
Moving to the next slide, I'm going to pause to allow the jurors to read.
Lori to Chad, I love you, heart emoji. Taking Braxy home now, which is Melanie Pelosi's kid. I'll check on her. Lori to Chad, she is asleep. She put a bunch of holes in the walls and doors. Definitely had demons helping her, probably 1,000. Lori says, Mel wants us to come up there tomorrow, but I said next Thursday to Sunday. What do you think? And Lori again says, we are both so tired of taking care of demons. We are weary. Please ask the Lord to take them. Kiss emoji. Oh yeah, Melanie P's just super innocent, super innocent. When's it her turn?
Would you please indicate the date these messages were sent into the record?
these messages were exchanged on August 7th of 2019.
Who were the messages exchanged between?
Lori Vallow and Chad Daybell.
And these messages were sent on the same day as those two images?
Correct.
What about these messages stood out to you?
The thing that stood out the most in this text series is in line 1391 in the text from Lori Vallow to Chad Daybell, where she indicates, "We are both so tired of taking care of demons. We are weary. Please ask the Lord to take them!" Exclamation point.
And Lori was sending that request to Chad?
Correct.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, please check JJ. He just woke up saying crazy stuff and won't go back to sleep. He is talking to Blake. It's weird. Lip emoji. Chad says, JJ is still JJ. I am told his spirit recognizes Blake as evil and is unsettled by him. Then later Chad says, hi, my love. How is JJ now? Lori says, he's better. He was just up talking nonsense for like 2 hours last night. I'm sure they were bugging him. Is he at 0 yet? I miss you, fire emoji.
And Agent Hart, can you indicate the date these messages were sent into the record?
These messages were exchanged on August 10th of 2019.
And is it fair to say that some of the next slides are going to correspond with the same date?
Yes, it's this slide and the next 5 slides are all a continuous exchange of messages between Lori Vallow and Chad Daybell.
What about this first slide with these messages caught your attention in relation to the investigation?
What first caught my attention is we see now, I believe, the 4th time that Lori Vallow is asking Chad Daybell to check on JJ. And Chad Daybell responds once again that JJ is still JJ.
And at this point, Charles has been dead for almost a month.
Correct.
Through the investigation and your review of the information in this case, did Lori have help with JJ prior to Charles passing?
Absolutely.
And who was helping her with him?
Charles Vallow spent a considerable amount of time and effort in caring for
Judge, I'm going to
JJ.
object at this point. Move to strike. There hasn't been sufficient foundation.
Sustained.
Through the review of iCloud, did you review videos?
Yes,
Did you review other content?
yes,
In that content, were there references to Charles taking care of JJ?
many.
And at the time these percentages are being pursued, Charles is no longer able to assist with JJ.
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, yes, he's at 0. He probably was partly through the veil talking to people, both light and dark. Lori says, maybe he was talking to the real Blake. Chad says, yes, that was the real Blake.
And Agent Hart, you'd indicated this is a continuation of the previous slide.
Yes.
And what about these particular messages caught your attention?
Well, primarily line 1170. In the last line of the previous slide, Lori Vallow asks Chad Daybell if JJ is at 0 yet. And we see Chad Daybell's response to that question, yes, he's at 0. He was probably partly through the veil, talking to people both light and dark.
And on the previous slide in this one, we again see a reference to Blake. Again, who was Blake?
Blake is Melanie Boudreau's child.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, do you think there's a perfectly orchestrated plan to take the children and we just have to wait for it to be carried out? Lori says, I feel lost, like I should be doing something to help. Chad says, there is a plan being orchestrated for the children. I was shown last night how it fit together, but it has been taken from my mind, of course. Holy
And
hell.
Agent Hart, is this again a continuation of the previous 2 slides?
It is.
Who are these messages being exchanged between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
This particular conversation is some of the most critical evidence that I located within the iCloud. It represents the clearest and most specific reference.
Judge, I'm going to object again. This is speculation.
Overruled.
It represents the clearest and most specific reference to a plan regarding Tylee and JJ. That plan is spearheaded by Chad Daybell.
Judge, I'm going to object at this point. That's a narrative
Also,
and it's argumentative,
it's sustained.
and I'm going to move to strike.
That last part of the comment is stricken.
When you indicate that there's the reference to the plan, who is asking if there's a plan?
Lori Vallow is asking Chad Daybell if there is a, quote, perfectly orchestrated plan to take the children.
What is Chad's response?
Chad's response is that there is a plan being orchestrated for the children.
Where were Tylee and JJ's remains ultimately located?
On Chad Daybell's property.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, "What should I be doing?" Chad says, "You're doing everything right, my love. The Lord told me she is right on track. He said to just keep resolving the telestial issues so you are unencumbered and fully free." Chad then says, "That actually feels good that JJ was talking to the real Blake, getting close. When I was sitting across from him eating bacon, I sensed he was barely attached to his body."
And Agent Hart, is this also a continuation from some of the previous slides?
Yes, it is.
Who are these messages being sent between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
Well, first off is line 1159. In the previous slide, there was a question about a plan and a verification of a plan. Then Lori Vallow asks Chad Daybell, "What should I be doing?" And in the subsequent line, 1158, Chad Daybell provides an answer to her, which concludes with being unencumbered and fully free.
There's also a reference in that to telestial issues. Do you know through the investigation what telestial would be referencing?
I do.
What is that?
Issues pertaining to this earthly life.
And in some of the previous messages, Lori was inquiring about the death percentages of Tylee Ryan and JJ Vallow.
That's correct.
What else stood out in relation to these messages?
Line 1155 is very critical. Chad Daybell texts Lori Vallow and indicates that JJ is, quote, getting close. When I was sitting across from him eating bacon, I sensed he was barely attached to his body.
Do you know when the last time JJ Vallow was seen?
I do.
When was that?
September 22nd, 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, "You're so incredible. In many ways, your mission has barely begun." Lori says, "As long as it ends with you, it's all good." Fire emoji. Chad, "Yes, cheek to cheek, loin to loin. It isn't very far away, my love." Kiss emoji, kiss emoji. Lori says, "Wish I could see with you and be cheek to cheek." Kiss emoji.
And Agent Hart, again, is this a continuation of some of those previous slides?
Yes, it is. And I believe there's one more that is part of this conversation.
I'm going to move to that slide and pause to allow the jurors to read that one as well.
Lori says, "I seriously cannot stop crying. I was allowed to," I'm sorry, Chad says, "I seriously cannot stop crying. I was allowed to feel my own emotions. I will experience as you sing to them, and the love, admiration, and reverence I have for you are indescribable. Everything we do together is going to be spectacular." Heart, heart, heart emoji. Lori says, "I can't wait, literally can't wait. I have no patience. I want you now." Fire, fire emoji. Chad says, "I'm certainly your biggest fan. I love you, Lily. Hold on, my sweet angel. We're so close to the finish line." Kiss emoji, kiss emoji. Lori says, "I'm trying." Chad says, "We'll make it." Heart emoji, and don't know whatever the heck the other ones are. Just repulsive.
And going back to that previous slide, what about this one caught your attention?
Well, this is just the continuation of the conversation. I think the more important content is on the following slide.
And what about these particular messages stood out to you?
Primarily lines 1117 and 1113. In 1117, Lori Vallow, as we've seen previously, says to Chad Daybell, "I can't wait, literally can't wait. I have no patience. I want you now," with 2 fire emojis. And then we see Chad Daybell's response to that, which point.
Based on your investigation, your review of the content of the iCloud, what did you determine the finish line to be?
The finish line was for Chad Daybell and Lori Vallow to live this fantasy life together that they had constructed and referenced in this plan that they're talking about.
Did that include being unencumbered?
Judge, I'm going to object. Calls for speculation.
Overruled.
Unencumbered from her husband and her children and from his wife. Yes.
Your Honor, looking at the time, I don't know if you'd like to do the mid-morning break.
I think this would be a good time for that. Thank you, Ms. Blake. We will take our mid-morning recess. We'll come back on just 10:30 or perhaps shortly before 10:30. Thank you.
All rise, please.
Well, I don't know about you, but I don't feel like eating even though I'm hungry. Let's have a chat. Okay, that was quite the morning. I love that Lindsay is bringing it on home. And oh, I look like a hot mess. What's going on? I look disheveled. She's doing a great job. And I love that she's bringing it on home. there's a couple spots where it was like, oh yeah, not only is he done, is Chad done, but he's double done. I mean, he's saying that, well, Lori says that she's tired of taking care of demons, and so is Melanie Pulowski. And Chad says that there's a plan that's being orchestrated for the children. And it's funny in ways that John Pryor keeps saying, well, where does it say that I'm going to take care of them? I'm going to finish the children or I'm going to kill them? Well, you want to see? This is where it's coming to. You want to keep bringing that up, John Pryor? Try me. Right? Right. Okay. John Pryor is with an I. You guys, thank you. I had to read those out this morning. You know what that's like for me? I have. It's been six weeks now that I've been doing this straight. And you guys have been coming in here. This is great. Yeah, I think they're doing a great job. It's going to be interesting now with John's witnesses, what's going to happen. I don't think Chad's the holy toast anymore. Pryor has priors. I have that video if you guys haven't checked that out. Okay, we can go over this. I'm just reading through some of the texts, the messages, or the, what's the word? The comments. Okay, so in the former FBI agent Douglas Hart is on the stand. He was there the day that the children were uncovered on the 9th and the 10th for the search warrant. He went through and said that on the evening of June 9th, Chad's children were asked to speak to the authorities. They initially agreed, but then they declined after speaking to Chad Daybell. And the agent said that there was thousands upon thousands of photos, emails, and messages in this case. It's been crazy, the amount of, it's voluminous. It's voluminous. Then John Pryor was whining about, he had an objection about some of the evidence. It was a nothing burger. There were texts, and that's what we've been reading for the last couple hours, is these texts from Lori to Alex. They had zombie talk, Lori to Chad, Chad to Lori, talk about his storm. We don't need to talk too much about that. Turning the pain up to 10, Chad was talking about. He was reviewing death percentages, and John objected to when it was read out, just grab me by the storm, and John, of course, objected. It's like, this looks really, really bad for me, Your Honor. There was lots of talk about Melanie Pulowski's kids and darkness and demons and Tylee switching and the death percentages. Now, in the rubric, you could be light or dark, and there's ratings, and then they get higher. And then the higher they go, you could be really light or really dark, which is what Charles was, and Tylee ended up getting that rating. JJ was light at first, then turned dark. But then you have these death percentages of where they go, and then the lower they go, they're ready to go. So it's basically Chad making up whatever the hell he wants and feeding it to Lori, and Lori being smitten because she's we call it D drunk. She's storm drunk and loving on Chad. And then they just have this disgusting conversation about getting rid of their children. I don't know. I don't know what else to say. Like it's terrible. So yeah, Lori says she's tired of taking care of demons, and Melanie is tired as well, and they're checking in to see if Blake and JJ's at a 0 yet. And Chad finally says there is a plan being orchestrated for the children. He said something really, really weird. Really weird. I find it weird to add this extra bit to it. I don't know why he put it in there, but that's me deciphering language, I guess. Where he says, when I was sitting across from him eating bacon, I sensed he was barely attached to his body. Do you find it weird that he added the bit about eating bacon? I find that odd. Maybe there was several times he sat down and that's why he said eating bacon, but I do find it odd at that point. Yeah, agree. It doesn't feel like 6 weeks, but then yes. Have I read those texts before in one of your videos? I feel like I have. Maybe not the eating bacon one. I feel like some of them I have. It gets hard after doing so many videos, trying to remember, did I read that, in a live or a video or, I feel like I have with Melanie's. It would be in Melanie's somewhere, I feel like. I can't remember the exact one though. If you guys remember, let me know. Yeah, we started on April 1st. Thank you. Does it look a little wild? I did curl it this morning for my video, but I didn't put my smoothing stuff, and it looks a little bit more nicer. Not more nicer. It looks more nice. Looks nicer. Anyway, whatever. I'm not a beauty YouTuber. So what I did love to This is hilarious. What I did like was when Lindsay was talking about Blake and she said, and how old is Blake? And the agent says 3 to 4 years old. Let that sink in for a moment. Please hit the like button if you have a moment while we are on break. That would be very, very appreciative. And in August 1st, we're going to go get Lori Daybell. We're going to go after her in that. So I will be streaming that. Corey Richins, her preliminary got pushed to June 18th. So we'll be able to share in that glory there. If you haven't seen Corey Richins, go check that out. She's like the baby sister to Lori Daybell and Letitia Stauch. Yeah, JP's going to be very interesting in this upcoming because now he's at the final countdown. Bubby is what she called Colby. People said Lori treated him more like a boyfriend than a son. That I wonder what that meant exactly. Colby did an interview with Justin Lum from Fox News in Arizona, and he talked about how Lori treated him more like a boyfriend than a son, and she was jealous of Colby's wife. And Colby's wife, Kelsey, was on the rubric as dark. And we know what happens when people go dark. Why aren't Chad's kids ever dark or light? Because he needed to manipulate Lori. The kids were adult kids. They were adult children. Chad's kids. So he didn't need to get rid of anybody. He wanted Lori all to himself, like you heard. And there were no obstacles in the way. Tylee was an obstacle. JJ was an obstacle. Colby wasn't an obstacle because he lived on his own and he was a full-grown adult. And I think that's exactly why Chad didn't include his kids either. It had to do with people who got in the way. And people who got in the way were Brandon Boudreau got in the way, even though he's an adult, but Brandon got in the way of Melanie, her life. Tammy got in the way of Chad's life, according to Chad. The kids got in the way in Chad's life, and Melanie Pulowski's kids got in the way of her life. And so they had to be taken care of. I will never listen to Bubby's the same again. I can't handle that. I can't handle. You know what I'm saying. Ashley. I want her to be charged. I did a whole, let's stick this playlist in here because she needs to be looked at, this girl. Melanie. Hello, sweet Melanie. I outlined so many discrepancies with that girl. I'm a little behind in your guys' comments. Were we at 67 witnesses? Was that the number? What's the video to Chad's rubric? Oh my gosh, I brought the rubric up so many times, his rubric. I called it his hit list. So if you go through, I mean, I don't know, do you guys remember? I have a ton. I talk about the rubric a lot, and it might come to me. I know, 1st of April was I know, isn't that crazy? Oh, you went to Mexico. That's right. You said that in chat, I think, in the beginning too, didn't you? I want to go on a trip. I haven't been on a trip in a very long time. They should be back on in 5 minutes or so. The break should be, yeah, maybe 5 to 10 minutes, and we'll come back. And I'm going to probably grab a snack. That's what I thought. I was saying that the other day. I thought it was boyfriend and hubby together. That's what I thought. Oh, that's what you're saying. Hello, I need to read. Yeah, that's what I thought. It was Bubby was hubby and boyfriend. But apparently Alex is also Bubby, but that doesn't mean that's not the meaning of it, because Lori, when she was younger with Alex, used to hop on him and wrap her legs around him and hop up and down, if you know what I'm saying. And that was said by Alex's first wife, who called the authorities, and that was on recording about that. Chad Daybell's children might believe in his innocence due to cognitive dissonance, as accepting his guilt would challenge their positive image of him as a father, leading to denial or rationalization. Thank you for that, and thanks for the super chat. Have you guys ever experienced cognitive dissonance? It is in different situations, it is difficult in relationships. And I had a chat about this not long ago about cognitive dissonance. Your heart says one thing, your mind says another thing. It could be. But after 4 years, I would wonder if they're following this, or, in the past, and they're asking words and asking things. It might be hard to believe, Chad, if that's what the case is. However, even in my 48-hour video, there was one of the children that you could tell he was like, I don't know about all this. Whereas Emma was, oh no, Lori did this and Lori did that. Okay. Bermuda. Absolutely. Yep. I've actually been there with a certain male species. Greece tomorrow too. That's amazing. Okay, I think I'm caught up to your guys's messages. I'm going to quickly run to get just grab a snack, because I'm starting to feel a little jittery. And you guys know what happens when I don't eat, I get silly. I get really silly. So I'll be right back. Don't go anywhere. Click the like button. Here, we'll put this up just in case they come back. Be right back. All right, I'm back already. I'm going to crunch in your ear for a sec. That's funny. Thomas says, Lynn has been on this case since day one. She understood things that were going on that wasn't confirmed until the trial. I knew it was bad, but oh my God, it's worse. Remember I said it's going to be really bad, worse than we thought. Yep. It's because Mr. Chad Daybell is a lot more evil.
All right.
And it's hard to see with the micro expressions, but it's there. And I have
Thank you. Please be seated.
out hopefully tonight, if not tomorrow, but it's already recorded this morning.
All right, Mr. Bailiff, we'd like the jurors brought in, please.
All right, please. Here's our present counter for you, Your Honor.
Thank you. Please be seated. All right, we're back on the record on CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Continuing with direct examination. Agent Hart, if you'd like to continue, Ms. Blake, you may.
Thank you, Your Honor. And may I go back to publishing?
Yes, you may.
And Agent Hart, we'd left off with this slide. Do you recall that?
Yes,
And we'd left off talking about the finish line.
correct.
Was this the last slide that was part of this particular series of texts?
Yes, it was.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Alex to Lori, Wi-Fi is in. What you doing? Lori says, working on Z's. What did you decide on username and password? Alex says, network name is Auntie Layman. Password is
And Agent Hart, can you indicate the date that these messages were being exchanged?
password too many
Yes,
kids.
this text exchange is from September 3rd of 2019
Who are the messages being exchanged between?
between Alex Cox and his sister Lori Vallow.
Do you know where Lori Vallow was living at this time?
Yes, both Alex Cox and Lori Vallow moved to Rexburg, Idaho from Arizona on September 1st of 2019.
Was there anything else about these messages that stood out to you?
Line 264 from Alex Cox to Lori Vallow, where he indicates the network password is too many kids, and her response is funny, exclamation point, exclamation point.
When was the last known sighting of Tylee Ryan?
Last known sighting of Tylee Ryan was September 8th of 2019,
And when was the last known sighting of JJ Vallow?
September 22nd of 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read.
I gotta finish chewing. Alex says, and I can change it to whatever you want if you want to change it. I am proud of you. No more Z's. Lori says, we're trying to get to the bottom of what we need to do to eliminate them completely. I'm sure you will be told also. Alex says, excellent.
And Agent Hart, is this a continuation from the previous slide?
Yes, it is.
Who are these messages between?
Again, between Alex Cox and Lori Vallow.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, these few messages provide a little bit of insight as to Alex Cox's role within this small circle of people, Lori Vallow and Chad Daybell.
And in that line, do you know what the Z's was referring to based on your investigation?
I do.
What would Z's be in reference to?
Z's is an abbreviation for zombies.
And then when we look to that line 261 in particular, was there something about that that stood out to you?
Yes, Lori Vallow indicates that they're trying to get to the bottom of what we need to do to eliminate them completely. And then she indicates to Alex Cox that he would be told also. And so to me, that sheds light on
Judge, I'm going to object. It's becoming a narrative and it's calling for speculation.
Overruled.
it sheds light on Alex's knowledge, how much knowledge he has, and that he too would be told what to do or what his role would be.
In your review of these messages, was Alex included in the text regarding death percentages?
He was not.
And this message indicates Alex would be told.
Correct.
And what was Alex's response?
Excellent.
And again, those messages were exchanged on September 3rd of 2019.
Yes.
What are we seeing in this slide?
This slide contains a very short, it's just a few seconds, video that I located within the iCloud. As part of our investigation, we went to great pains to try to determine when Tylee was killed and when was the last known sighting that we could verify. And that last known sighting is on September 8th, 2019. This is a video of a trip that was taken with Lori Vallow, Alex Cox, JJ, and Tylee to Yellowstone National Park. It's the last known living proof for Tylee.
And this is 5 days after the messages about eliminating zombies completely,
Yes,
and 5 days after the messages about Alex being told what to do.
yes.
And who else was in that video?
Tylee is hugging her younger brother JJ, and Alex Cox is standing off to the side.
Can you tell us what we're seeing in this slide?
Yes, in a similar vein, we searched for what would be the last known sighting or living proof of JJ. And this is what I located on the iCloud. It's from September 22nd of 2019 at 10:46 a.m. in the morning. Subsequent to this video, there are no other photos or videos existing in the iCloud of JJ.
And again, where were JJ and Tylee's remains found?
At Daybell's property.
Moving to the next slide, I'm going to pause to allow the jurors to read.
From Sydney to Lori. Hi, Lolo. Are we still good for me coming today? Lori says, hi, Sydney. I hope the wedding was good. So JJ's grandparents came this weekend and they took him for a few weeks to give me a break. So we won't be back until probably the end of October. I wish I had other work for you to do. You are such a darling girl. I understand if you need to get another job. Lori says, of course, I'm not sure when he will be back, but I'm going to do some traveling while he's gone, probably to see my friend in Hawaii, but I'll let you know for sure when we are both back in Rexburg. You are great. That's the babysitter. And she said that Tylee only wanted to get paid when she babysat. Like Lori said, a bunch of crap. By the way, did you hear that? It sounded like
And Agent Hart, can you indicate the date these messages were exchanged?
These are from September 24th of 2019.
Who are these messages between?
These are messages between Sydney Woodbury and Lori Vallow.
And in relation to this date, was it significant?
Yes,
And why was that?
the date is 2 days after our last known living proof for JJ.
What else about these messages stood out to you in relation to your investigation?
These are the first lies we can find documented by Lori Vallow regarding JJ and his whereabouts.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, good night, Angel Lily. So excited to go on our date. Lori says to Alex, we are supposed to go on a real date tonight, but we are discussing it. Perhaps an evening at home would be better so we are not out and about. I'll let you know, but you could come and sing with us after your shower. This is October 4th. Tammy was urged to go to Springville. Chad says, hello, sweet angel. Big news about Tammy. Please let me know if you're awake and can talk. I love you. That's the next day.
And Agent Hart, there's 3 messages here that all contain a different date. Is that correct?
It is.
At the time these messages were exchanged, was Charles Vallow alive?
No,
Was Tylee Ryan believed to be alive?
no,
JJ Vallow believed to be alive?
nope,
Was Tammy Daybell alive?
yes.
Looking at the first message, can you indicate the date that was sent?
First message was sent on October 3rd of 2019.
Who was it being sent from and who was it going to?
This was a message from Chad Daybell to Lori Vallow.
Was there something about that message that stood out to you?
Yes, Chad Daybell indicated that he was so excited to go on a date with Lori Vallow.
And the next one, can you indicate the date?
It's the following day, October 4th, 2019.
And who is that message from?
That's a message from Lori Vallow to her brother, Alex Cox.
And what about that, if anything, caught your attention?
Well, at this point, both Alex Cox and Lori Vallow had moved to Rexburg, Idaho, were living in Rexburg, Idaho. And the investigation indicates that Tylee and JJ were both deceased at this point. Lori Vallow says to Alex Cox, "We are supposed to go on a quote real date tonight, but are discussing it." And then she indicates perhaps an evening at home would be better, so we are not out and about.
And again, at this time, Tammy Daybell is still alive.
She is.
Where was Lori Vallow living at this time?
She was living in Rexburg, Idaho, which is a very short distance from Sugar City, where the Daybell residence was located.
And then looking at that last message, can you indicate the date?
October 5th, 2019.
Who was that message being sent from and who was it going to?
So this is a message from Chad Daybell to Lori Vallow. And then there will be two more slides that are a continuation of Chad Daybell reaching out to Lori Vallow approximately 12 hours after the prior text indicating that an evening home may be better rather than a real date.
And in that last message, can you read that last message into the record?
"Hello, sweet angel. Big news about Tammy. Please let me know if you are awake and can talk. I love you, !" And then heart and lip emojis.
There's an indication in there from Chad to Lori that there's big news about Tammy. Is that correct?
That's correct.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says the short version is that she has been switched. Tammy is in limbo and a level 3 demonic entity named Viola is in her body. It happened at about 10 p.m. and was done by Tammy's sister Sam, who I always knew was 3D, but it turns out she is multiple creation. Chad goes on to say, Viola has been attached for about a year to my niece Danica, who is Sam's 12-year-old daughter. I have connected with Tammy in limbo, and she is very frustrated and upset. She wants Viola removed as soon as possible. Viola seems to be similar to Penelope. The personality differences from Tammy should be evident quickly. Please seek a confirmation on this. But I have now checked 3 times since I got home and get more affirmative answers each time. Cheese and rice, this is crazy.
And Agent Hart, can you indicate the date these messages were exchanged?
Yes, the date is October 5th, 2019. And the times are within minutes of one another, as well as within minutes of the prior text where Chad Daybell indicated he had big news about Tammy.
And looking at these messages, were there things that caught your attention?
Yes, there's 2 text messages on this slide and then 2 more text messages. All 4 of these text messages are from Chad Daybell to Lori Vallow. I found no response from Lori Vallow to these messages. But in these messages, Chad Daybell is providing an explanation, a narrative indicating that Tammy has been switched and that there is a demonic entity that is now in Tammy Daybell's body that she wants removed. And that word removed, I think, is critical.
And do you see in here a reference to the name of the demonic entity?
Yes, the name that Chad Daybell assigns to this demonic entity is Viola.
Judge, I'm going to object, move to strike. There's no testimony regarding who assigned what.
Overruled.
What is he smoking?
We talked about the word removal based on your review of the iCloud account, your review of other things involved in this investigation. What was significant about removal?
Removal indicates the physical death of the person who has the demonic entity.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, Sam is much like Brandon. She has been my biggest enemy over the years. She refused to read my books and threw the biggest fit when we moved to Idaho. She has only visited us when the kids got married and always fled Idaho within hours like she was being burned. She's definitely comparable to Brandon and Summer, and Sam is Tammy's sister. Chad then says, not fully sure of the timing for removal, but once her actions verify the differences, I don't want to wait.
And Agent Hart, I believe you indicated this is a continuation from the previous slide.
It is. These are all, I believe the very first text message was 4:36 a.m. And so the final text, the final and fifth text message in this string, all from Chad Daybell to Lori Vallow, is at 4:54 a.m.
And again, what day?
on October 5th of 2019.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, line 769 is a crucial piece of evidence from the iCloud that is a very specific reference to the alleged crimes involving Tammy Daybell.
Judge, object. Mischaracterization, speculation, argumentative.
I'm going to sustain that as argumentative.
We had just talked about the meaning of the word removal in the investigation. Do you see reference to removal in this line?
I do. Chad Daybell writes, not fully sure of the timing for removal, but once her actions verify the differences, I don't want to wait.
What happened on October 9th of 2019?
October 9th,
Answer, Judge.
What was that?
Objection. I asked and answered.
Overruled.
on October 9th, 2019 was the first attempt on Tammy Daybell's life.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Unknown individual to Lori says, I'm not sure if you heard, but Chad's wife died last night. Lori says to this unknown individual, oh my gosh, I did not hear that. I'm in Hawaii and it's 6 a.m. Lori to this individual, do you know what happened? And text to Lori, yes, she awoke in the night coughing, threw up, collapsed.
And Agent Hart, can you indicate the date these messages were being exchanged?
These are messages exchanged on October 19th, 2019.
What was significant about October 19th of 2019 in your investigation?
That is the date of Tammy Daybell's death.
Who were these text messages being exchanged between?
This is between Lori Vallow and an individual who wasn't identified by name within the iCloud. So I can't tell you who this is that's telling her this information.
What was significant about these messages? Or let me withdraw that. What caught your attention in relation to these messages?
Simply that someone knew that Tammy Daybell had died and then provided that information to Lori Vallow, who was in Hawaii at the time.
Do you know where Chad Daybell was at the time?
In his residence in Sugar City, Idaho.
Do you know where Alex Cox was?
Alex Cox was in Rexburg, Idaho.
And moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, not fun without you. Can you call me? And says, how are you doing is the question. Chad says, I'm hanging in there. My parents are staying here and we are all still getting visitors, but I will call you soon. This is on October 9th at around 10 p.m. Sorry, October 19th when Tammy died.
And Agent Hart, can you indicate the date these messages were exchanged?
Again, on October 19th, 2019.
And who were these messages being exchanged between?
These are between Lori Vallow and Chad Daybell.
What in relation to these messages stood out to you in relation to the investigation?
Primarily the timing of the messages in conjunction with Tammy Daybell's death. And then this is the first in a series of messages over the next 24 hours or so between Chad Daybell and Lori Vallow subsequent to Tammy Daybell's death.
And again, Tammy Daybell was pronounced dead on October 19th of 2019.
Yes, the call, the 911 call was approximately 6 a.m. on October 19th, 2019.
So the same day these messages are exchanged.
Correct.
And move to the next slide and pause to allow the jurors to read.
Chad says percentage in body, Holzer 24, Eucola 11, Grisone, I don't know, 14. This is a weird name. Chad says, great job on lowering them. I love talking with you. It is baby night, so come get me later. Chad says, missing you so much. I can feel you in bed with me, though. Can't wait to truly hold you tightly every day and night. Lori says, I'm missing you more. I need you desperately. I
And
can't.
Agent Hart, can you indicate the date the messages were exchanged?
These messages are on October 20th, 2019.
And who were these messages between?
Chad Daybell and Lori Vallow.
And this is the day after Tammy's been pronounced dead.
Well, the first two messages, as you can see, are just past midnight. So they're approximately 18 hours after Tammy Daybell's death. And then the last two messages are approximately 25 and a half hours after that 911 call regarding Tammy Daybell's death.
What else about these messages stood out to you in relation to the investigation?
Well, line 527 on that date is a text from Chad to Lori Vallow, where he indicates, I love talking with you. It's baby night, so come get me later.
Do you know where Lori Vallow would have been at that time?
She's in Hawaii.
In the messages that you reviewed shortly after Tammy's death, any expression of grief by Chad Daybell regarding his wife's death?
None.
Any expression of grief by Lori Vallow?
None.
And if you recall, when you testified previously, you'd reviewed messages around the time of Charles' death, is that correct?
Yes.
Any expression of grief by Lori in those?
None.
Any expression of grief by Chad in those?
No.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, need you to hold me tight. That would be great. What about the idea of you coming here Thursday or Friday, or do you want me to come home? Chad says, their apartment is haunted and we can't clear the place, so they're looking to move anyway, and I have the perfect place for them. I need to be here to get sorting the financial stuff, and I truly need your help. So please come home Thursday so we can spend the night together. Then as soon as I have things under control, we can return. I seriously want you to look for a condo for us while you are there that we could return to at the first of the month. One day after Tammy died. Not even. Yeah, one day.
And Agent Hart, can you indicate the date these messages were exchanged?
October 20th of 2019 in the early morning hours.
And who are they being exchanged between?
Again, it's a continuation between Lori Vallow and Chad Daybell.
Were there things about these particular messages that stood out to you in relation to the investigation?
We're now getting into the logistics of Chad Daybell and Lori Vallow being together subsequent to Tammy Daybell's death. Lori Vallow actually invites Chad to jump on a plane and come to Kauai. And Chad Daybell responds that she should come back to the mainland so that they can spend the night together on Thursday, and then indicates wanting to look for a condo so that they could return to Kauai at the first of the month, meaning November.
And do you recall from your previous testimony reviewing some messages regarding a plan to be in Kauai?
I do.
And who was that plan between?
Chad Daybell and Lori Vallow.
Do you know if Chad and Lori were ultimately married?
They were
Where did they get married?
on the island of Kauai.
Do you know where Chad Daybell and Lori Vallow moved to?
The island of Kauai.
And this conversation took place about 25 hours after Tammy Daybell had been pronounced dead?
About 26 hours after the 911 call by Chad Daybell to indicate to authorities that his wife was dead.
I wanted her to say about Chad moving.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Chad says, I want to get going full steam on the Lily workout plan, tighten the abs, get a full body tan, grow my hair out. This could be really good for both of us. Lori says, I love that plan. It's not soon enough, though. This is torture. Maybe you need to clear my mind so I can't remember how much I love you. And then Chad says, I will try, but it feels like Raphael and Lily are together at about 100%. Not sure it will ever be lower again.
And Agent Hart, would you indicate the date that these messages were exchanged?
October 20th of 2019.
And are these a continuation from some of the previous slides we've reviewed?
Yes, they are.
And who were these messages between?
Chad Daybell and Lori Vallow.
In relation to your investigation, what stood out to you with these messages?
Again, it's a continuation of the fulfillment of their plans to be together. The first line 5118, Chad Daybell indicates a workout plan for Lily, who is Lori Vallow, that he wants to tighten his abs, get a full body tan, grow his hair out, and that it could be really good for both him and Lori Vallow.
And in that last one, 516, do you know who Raphael and Lily is referring to?
Those are, again, alternate names for Chad Daybell and Lori Vallow.
And is there an indication there about how much they will be together?
100%.
Moving to the next slide, I'm going to pause to allow the jurors to read.
It's okay. That's true. I do feel you. I feel lovesick. I can't sleep. This is from Lori. I don't want to eat. I just want you. It's so consuming. And Chad says, I know exactly how you
Agent
feel.
Hart, can you please indicate the date these
I'm
messages were
feeling
exchanged?
sad, but it isn't the reason
Yes, this is the conclusion of this text string, and the date is October 20th, 2019.
And who are the messages between?
Lori Vallow and Chad Daybell.
Was there anything that stood out to you in relation to the investigation in these messages?
Yes, in line 515, you have Lori Vallow indicating how consuming her love is for Chad Daybell. And then of note, line 514, Chad Daybell responds, I know exactly how you feel. I'm feeling sad, but it isn't for the reason everyone thinks, exclamation point.
Through the investigation, did you learn what the connection between Alex Cox and Chad Daybell was?
Yes,
What was that?
Alex Cox was an adherent of Chad
Judge,
Daybell.
objection, argumentative.
Sustained.
Did Chad meet Alex through Lori?
Yes,
Based on your investigation, review of messages, and other things, would Alex do as Chad asked?
Judge, objection, argumentative.
Overruled.
yes,
Did Tammy Daybell know Alex Cox based on what you learned in the investigation?
no, she did not.
Was the only connection between Tammy and Alex Chad?
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read.
Lori says, I had a bad dream about Al. Make sure he is still him and protect him. She says he would be the one they use to get us both. All this alone time is not good for him. Chad says, I will try to reach out to him later today. And then he says, I just cleared all of Al's weapons, curses, and cords and filled him with malachite healing balm. I also put angels around him.
And Agent Hart, can you indicate the date these messages were exchanged?
Yes, October 23rd of 2019.
And who were the messages being exchanged between?
Lori Vallow and Chad Daybell.
And do you recall in a previous slide talking about a message where Alex was to be told information also?
Yes.
What about these messages stood out to you in relation to the investigation?
In relation to the investigation, primarily lines 482 and 481 stood out to me. In line 482, Lori Vallow indicates she's had a bad dream about Al. And primarily line 481, Lori indicates that Alex Cox would be the one they use to get us both. All this alone time is not good for him. So something that Alex Cox knows is a risk to Lori Vallow and Chad Daybell.
Based on your investigation, review of the iCloud, and other information, who was the they being referred to?
Objection, speculation.
Overruled.
I believe that is a direct reference to law enforcement.
What is Chad's response in line 479?
Chad Daybell indicates I will try to reach out to him later today.
So Chad was going to be the one to reach out to Al,
Correct.
and Lori was requesting Chad's help with talking to Al.
Correct.
And again, through your review of the messages, who was seeking information?
Primarily Lori Vallow,
And who was providing the answers?
primarily Chad Daybell.
I have no further questions.
All right, thank you, Ms. Blake. All right, Mr. Pryor, cross-examination.
Thank you, Judge.
Here we go. Portal potty initiated.
Agent Hart, there was a discussion about when you're investigating missing children, who the potential folks that you would look to if you were starting your investigation. Do you recall that discussion?
Yes.
Wouldn't it be fair to say that an obvious person to look for or look at when you're investigating missing children would be a new husband?
In addition to others, yes. We would look at the parent or the husband. I guess my point was you can't put blinders on. You can't exclusively hone in on one person at the onset of an investigation.
Right, and it would be inappropriate to do that. I mean, when you're looking and conducting an investigation, wouldn't it be fair to say that any and all evidence that you obtain, you should look at all leads of evidence and not target your investigation in one channel? Would that be fair?
Yes, that's what we did.
Okay, and that's what you're, as far as the FBI, that's what you did, right?
I participated in dozens of meetings with the Rexburg Police Department and the Fremont County Sheriff's Office. It's my belief that's what all of us did.
Okay, so again, just to reiterate, it's your contention that you didn't fail to investigate or look into evidence that might lead you in a different direction. Would that be fair?
That's correct.
Okay. Now, as part of your FBI training, you talked about that you were involved in the task of looking for identifying missing children, correct?
Yes.
And as part of that FBI training, is it your experience or the FBI's experience that they ever utilize the use of a medium to try to locate or talk to children who have passed on?
It's extremely common for people who claim to have those abilities to come forward, but no, the FBI does not employ mediums in its investigations.
And I didn't say employ, I said utilize, but do you know the name Allison Dubois?
I believe I'm familiar with that name, yes.
And Ms. Dubois is a medium who claims to have the ability to talk to children and to.
Objection, Your Honor. Counsel's testifying. Move to strike.
Sustained.
What is your knowledge of Allison Dubois?
It's my belief that she holds herself out to be a spiritual medium.
And that spiritual medium is being able to talk to children who have passed on?
I couldn't say specifically what abilities she claims to have.
Okay, and I don't want to say employ, but has the FBI or any agency you've been involved in ever employed Allison Dubois or any other medium in helping gain information?
Objection, Your Honor. Relevance.
Overruled.
Gain information about the whereabouts or the circumstances surrounding the death of a children or anyone in particular.
Well, Mr. Pryor, when I said employ, I think I mean the same thing you do as utilize,
Okay,
not pay money to. I've never spoken with Allison Dubois. I've never requested her services. To my knowledge, nobody in this investigation requested her services. Many times these people come forward offering their services and offering what they claim to have seen.
so you are familiar that there are people out there who, as a professional occupation, claim to be able to engage in these spiritual exercises, for lack of a better word, correct?
Objection, Your Honor. Relevance.
Sustained.
Okay. So would it be fair to say that if Chad Daybell placed himself out as someone who claims to be able to have these spiritual gifts, that in itself is not unusual? Would you agree with that?
I don't believe it's common.
Okay. Your concern is that the number of text messages in reference to Tammy and the children, that's where you say that's where we potentially have a problem, correct?
Given what happened to Tammy and Tylee and JJ, yes.
Okay. Now, I noticed during your dissertation with all of your exhibits, on around 8/11, August 11th of 2019, it appears that there are some captions that were left out regarding a breakup between Lori and Chad Daybell. Do you recall that?
I believe those were included in the first testimony that I provided a number of weeks ago.
Okay, and those were not included in today's testimony, is that right?
They were not part of today's testimony.
Do you have a specific recollection of what was involved in the language that was used that you could read and provide us in terms of testimony regarding those emails?
Yes, I can certainly give you my best recollection. It won't be verbatim, and if you want verbatim, we'd have to go back to the exhibit that was used during my testimony previously.
And Judge, previously, the state and the defense stipulated to the admission of the Lori for Style contents of that particular account. I'm holding in my possession Exhibit 7U. I'm going to ask that the court mark this as an exhibit and move for admission by, I don't know that the state has an objection to that.
The state does not have an objection. I just wanted to clarify which ones.
Very well. We'll get that marked for you, Mr. Pryor, and then.
Thank you, Judge.
Can you clarify what's in 7U?
Judge, it's a content of approximately 4 text messages between Lori Vallow and Chad Daybell dating from 8/11 of 2019.
All right, Exhibit 7U is marked and will be admitted.
Thank you.
This is painful. Imagine next week with all his witnesses.
Judge, may I have the court's permission to publish?
Yes,
And it might take me a minute, Judge. For more than a minute.
Let us take a moment to collect the lapidity.
Judge, if we could start publishing.
Let's
all right,
zoom it
we
in.
will.
No, officer, I apologize. Agent, line 856 talks about from Chad Daybell to Lori Vallow, the next 2 days will be torture. Do you see that?
I do.
Then there's a comment from Chad, makes a comment, and could you read that thankfully?
Thankfully, I will be alone most of Wednesday and beyond.
Okay, and then we go to line 854. Are these there's no text messages that are in between each of these, is that correct?
So in the iCloud, there can be. So in between 856 and 854, Lori Vallow could have gotten a text from a friend about lunch. And so they're just arranged and given a line number based on the date and time. So that's how this works.
Okay, so the time on the first one, 856, is at 9:56. The 854 would be the next correspondence from Lori Vallow to Chad, correct?
Yes.
And if you could read that entire text message, starting with the word is.
Is that what he wants? For me to sit around waiting for you endlessly and you miserably wasting time? It just doesn't feel right! Exclamation point.
Okay. Now, you talked about the manipulation that was engaged in these, many of these, and you said, use the word many, from Lori Vallow to Chad Daybell. Is this an example in your mind of Lori Vallow again manipulating Chad Daybell?
Absolutely. It was a two-way street. Lori Vallow would manipulate Chad Daybell and vice versa.
Okay, and Chad's manipulation would be talking about the religious knowledge that he claims to have in this vast wisdom. Is that right?
Yes.
Okay. So on 2 levels, we have manipulation, at least according to you. We would have manipulation because someone's claiming to have some religious knowledge and espouses that by trying to impress Lori Vallow with that vast religious knowledge, correct?
I think it's more than knowledge. I think it's direction.
Okay. And then in Lori's case, this is manipulation and trying to get Chad to do what she wants him to do, correct?
Yes, I would agree.
Okay. Okay. And Judge, could we unpublish at this point to move to the next slide?
yes.
Thank you, Your Honor.
vast wisdom.
Okay, and then if we could publish again.
Go ahead.
And then again on 8/11, it talks about Chad to Lori Vallow, I'm frustrated. I'm sorry, honey. And then let's go to line 843, which appears to have occurred at about the same time the first text. And if you could read line 843, starting with you.
You can't just keep tearing my heart out. I really can't take it anymore. I'm sorry.
Okay. Okay. And then let's go down to line 841 and start with reading that one for me.
What about the past 2 days? I didn't even get to talk to you on your birthday. I'm clearly not a priority. I just don't want to be so sad all the time and do heartbroken.
And again, in your professional experience with dealing with this case, is that another instance where Lori Vallow may be trying to manipulate Chad Daybell?
Certainly.
Thank you. And Judge, if we could unpublish again.
Yes.
And let's publish again, Judge. Okay. And then if you would read line 840.
If you really loved me, you wouldn't want that either.
Okay. And then Chad Daybell responds. That was from Lori Vallow to Chad, correct?
Yes.
And then 2 minutes later, Chad discusses that he couldn't have talked. The girls were there. And then he expresses his true love for Lori Vallow, correct?
Yes.
And then if you would be so kind, 2 minutes later at 10:15, Lori Vallow texts Chad Daybell. And if you could read the entire line starting with you.
You should give all of you love and your attention to your wife and family. I'm just a distraction. Go have fun with your family. I really do want you to. I just can't be in the way anymore. If things change, then we can talk. But we have nothing until things change anyway.
And once again, I don't want to keep reiterating this, but this is another example of Lori Vallow attempting to manipulate Chad Daybell. Would you agree?
I would.
Okay. And it seems a little bit final. And it seems as if that the suggestion here is on 8/11 of 2019 that there's a breakup between Lori Vallow and Chad Daybell. Do you agree with that?
I do.
Judge, we can unpublish this.
All right.
I'm going to use John's words. Does it say breaking up there? It does not say breaking up.
All right, that concludes cross. Any redirect?
Yes, Your Honor.
Go ahead.
Oh, I'm sorry.
Bring it on home, Lindsay.
Your Honor, I would request permission to publish from 183B, the printout of the PowerPoint. I can use the drive if necessary.
All right, we'll get you the exhibit on the drive.
Agent Hart, you were asked about manipulation by Lori Vallow from counsel. Do you recall that?
I do.
Through your investigation, did you also find manipulation by Chad Daybell?
I did.
Did you find that manipulation around the same time of the breakup?
I found it throughout the entire course of the investigation.
And again, through the investigation and based on your review, who would determine someone was dark?
Chad Daybell.
Who would determine if someone was a zombie?
Chad Daybell.
Who would determine?
Judge, I'm going to object at this point. It's going beyond the scope of cross-examination.
Overruled.
Who would determine death percentages?
Chad Daybell.
And Your Honor, I would request permission to just publish one page of the slide, but to print it out for ease.
Yes, you may publish the printed version on the Elmo if you'll identify what it is when you do that.
Yes, it is slide 18 from the printed version of Exhibit 183B.
Oh, that's the plan that's being orchestrated for the children.
Agent Hart, who is the one that indicates there is a plan being orchestrated?
Chad Daybell.
And do you see the reference in there to the children?
I do.
Do you know where Tammy Daybell's body was located when she was pronounced dead?
Tammy Daybell's body was located in the bedroom in their home.
Where were the bodies of Tylee and JJ located?
Tylee and JJ were both located on the pasture property of the residence.
And was that the residence of who again?
Chad Daybell.
I have no further questions.
All right, thank you. That will conclude the testimony then of Agent Hart.
Boom.
Does the state have any additional witnesses to call in its case in chief?
We do not, Your Honor.
All right, so has the state rested at this time?
Judge, if we may have a brief sidebar.
Yes.
Ooh, sidebar. Didn't say they're rested. What's going on? The plot thickens. Dun, dun, dun. What's going on? What's going on, guys? I love how she brought it back to, and where was Tammy Daybell's body found? Chad's house. Where were the children found? Chad Daybell's yard. Huh, nothing further. What do you think Chad's thinking right at this moment? Holy F, I hope John Pryor can come up with some BS to get me out of this mess. I want my loin fires to connect with Lori. He looks like he's a little bit of a different demeanor right now. He's praying. He is praying. Now he's looking up. Chin's not so high, is it, Chad? Not, oh, maybe a little bit. No, looking down now. Looking down, wondering what he's going to have for lunch. Okay, what are they talking about? Yes, Brooke D. I have a video tonight, tomorrow. I've already filmed it this morning. Exactly what you're talking about. I may. Well, hello, Sue's hubby. Glad you guys could laugh a little bit. Yes, talk about a celebration lunch. Okay, come on. What's going on here? The suspense right now. What did I write down? Alison Dubois. I was going, wait a minute. I remember watching that show like years ago. And apparently that's based on an actual person. And so when he started bringing Alison Dubois, I was like, what is going on? And then there was an objection by Lindsay, and the judge goes, overruled. Overruled? What is he talking about, overruled? Yeah, scam sandwich for Chad's lunch hour. With limp fries. She's not done kicking their butt yet. It's just like the mic drop. Boom. Come on. Larry's standing up. Is he just standing up or is there something going to happen? Ooh, look at him. I am up. I am up, Larry. Give him the stare of darkness. Yeah, buddy. We love you, Larry. We love you. This is good. I'm taking screenshots. Poor family, too, to be how many months of their life just in trial alone. You guys is like, my heart is starting to pound. And Judge just sitting there. Oh, he glanced over. He glanced over at Larry. Now looking away. You feeling that, Chad? Okay, here we go. Go, Larry. Go, Larry. Okay, what's happening?
All right, we just had a sidebar to discuss some scheduling matters. At this time, I had inquired from the state if the state had another witness to call at this time or whether the state had concluded its case in chief. Ms. Blake?
The state does not have any additional witnesses. The state rests.
All right, the state is now rested. Ladies and gentlemen of the jury, in terms of our scheduling, that is going to conclude the evidence portion for today. We did not provide lunch today, believing we'd end here early. However, before you leave, you'll be delayed a little bit while the jury commissioner is going to just talk to you about a little additional information and scheduling at my direction. And so we will take up those matters with you shortly. And at this time, then we'll take a recess. And then if the parties wish to come back on the record for any motions outside the presence of the jury, we can do that as well. So we'll take our recess at this time and let the jurors be excused to the jury room. All right. All right, thank you. Please be seated. I'll note that the last witness, Agent Hart, is still, I'm advised by the state, I believe, going to be held under subpoena potentially for rebuttal. Is that correct?
That is correct, Your Honor.
Okay, we just advised the witness he's done for today, but he's still subject to the exclusionary order. At this time, also then, I do want to take a recess here because I do want to meet briefly with the jury commissioner, and we'll take a break, and then Mr. Pryor, is the defense intending to make any motion today?
Judge, I anticipate making a motion, a general motion for a directed verdict, Judge. I'll describe it that way.
Okay. Why don't we plan on that? I know it's maybe an inconvenient time, but in about 30 minutes probably. So
Thank you,
10
Your Honor.
after. We'll take the motion up then.
Thank you, Judge.
Okay, thanks. We'll be in recess until then.
All rise.
All right. So let's just chit chat for a moment. So the prosecution rests. Sounds like there's something, a directive verdict. There's a motion. Of course, there's going to be a motion. Someone gave me a lemon drop. There we go. Lemon drop martini for our humble moderator, Linda. Yeah, let's have a lemon drop martini today. We are going to see what happens in a half an hour. Now, here's the interesting part. I have a meeting, but this will obviously be up and we'll have to figure that out. Maybe it'll go long enough that after my meeting, I can come back and we keep chit-chatting, and then we'll see what happens. I will be behind the scenes, you guys, in my meeting. He's saying a half an hour, so that's about 10 after 12. I'm going to hop on the meeting now. I could go a little bit early and we'll see what time I get to, but I will be back. It's just a case if you guys are going to hang out and see how long this motion's going to take. And we'll find out also what's going to happen with John Pryor's witnesses, if they're going to start tomorrow or if it's going to be on Monday. Yeah, just there's no like dismiss the case. Hilarious. I know I can't, but I have an important meeting. It's for the channel. I know. Okay, so there's no way. There's no way that's gonna happen. It's just people are gonna laugh. It's no big deal. Okay. Thank you. That's very nice. It's like a coral color. Okay. Okay, so I'm going to go on right now. Let's hope they take a little bit longer and I can get back on, okay? Chat with you soon. I'm just going to make that big. And we'll see what happens. It's fine. We're going to be fine. I'll see you in a bit. Oh, maybe I should put the banner up. Maybe not. Okay, I'll see you in a bit. Chat amongst yourselves. Chat about the day. Chat about what's coming. Who you think John's going to bring on. And then I will be back. I promise.
All rise. Mr. Court's again in session.
Thank you. Please be seated. All right, at this time, we're back on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. The court will note that the state has rested its case in chief. At this time, then, I understand the defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges. Specifically with Tylee and JJ, there is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges, and they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear that a motion for judgment of acquittal should only be granted when there is no evidence upon which to base a verdict of guilty. And that is from State versus Vargas, 100 Idaho 658. Essentially, the trial judge must review the evidence in the light most favorable to the state, recognizing full consideration must be given to the right of the jury to determine the credibility of witnesses. The jury gets to determine the weight of the evidence, as well as enjoying the right to draw all reasonable inferences from that evidence. And that's from State versus Huggins, 103 Idaho 422. Going through the charges in this case, Your Honor, first beginning with the conspiracy to commit the first-degree murder and grand theft by deception related to Tylee Ryan. The state charged a series of overt acts, and the state has presented evidence on all of those overt acts. Number one being that the defendant endorsed and espoused beliefs designed to justify the homicide of Tylee Ryan. Specifically, statements made about her being dark. These beliefs were part of the defendant's teachings, and it would be very reasonable for the jury to draw the inference that these beliefs that the defendant was espousing were designed to dehumanize these victims and justify their homicide. As to number two, that his co-conspirator Lori Vallow changed the deposit on Tylee Ryan's JP Morgan Chase account to her BBVA account. We also heard testimony from the state's financial witnesses to that effect. Evidence that his co-conspirator and then mistress, Lori Vallow, moved to Idaho with his other co-conspirator, Alex Cox, as well as JJ Vallow and Tylee Ryan. Multiple witnesses testified to this. We heard evidence that the defendant himself did Google searches for the wind direction on September 8th of 2019, last day Tylee Ryan was seen alive, and the day prior to when the state presented evidence that Tylee Ryan would have been buried on the defendant's property that is directly related to the defendant. Number 5, Alex Cox went to co-conspirator Lori Vallow's apartment where Tylee Ryan lived in the early hours of 9/9. Certainly there was evidence presented to that effect. And of note, there was also evidence that the defendant was in communication with Alex Cox at that time, and that Alex Cox's phone was in the vicinity of the defendant's residence. As to number 6, that Lori Vallow never contacted Social Security. There was also testimony presented to this effect. The jury also heard that just weeks prior to Tylee Ryan's death, that Lori and Chad was aware that she would still be getting those Social Security checks after the death of Charles Vallow, which does link the defendant to that co-conspirator's actions in never contacting Social Security. Additionally, the 7th overt act, that from September of 19 to January of 2020, Lori Vallow continued to collect those checks. And during a substantial portion of this time, Your Honor, the defendant was living with her in Hawaii and enjoying the proceeds of those checks, another reasonable inference that the jury could draw. As to the first-degree murder charge of Tylee Ryan, which is count 2, the jury heard evidence that the defendant claimed that Tylee Ryan was dark, that he was, again, exchanging text messages with Alex Cox the day after she was last seen alive, that Alex Cox was in the vicinity of his residence. The jury heard evidence that the defendant texted his wife the morning of September 9, claiming that he had shot a raccoon and burnt some limbs. And then Tylee Ryan's burnt and dismembered remains were found on the defendant's property. Her DNA found on the defendant's shovel and the defendant's pickaxe in the defendant's shed. So I think there's ample evidence on that count, Your Honor, and I think that does not merit even consideration of a judgment of acquittal. As to count 3, I won't rehash all the overt acts because there is some overlap with the count 3 conspiracy to commit first-degree murder of J.J. Vallow. The first overt act we've already discussed, which is the evidence of those espoused religious beliefs justifying the homicide of J.J. Vallow. Number 2, we've already covered that the defendant's co-conspirator and then mistress, Lori, moved to Idaho with the children and with Alex Cox. Overt act number 3, the jury heard evidence that Alex Cox, the defendant's co-conspirator, took custody of J.J. Vallow. As to overt act number 4, that co-conspirator Lori Vallow provided false information to law enforcement regarding JJ's whereabouts. We did hear testimony of that as well. Number 5 and 6, again, those are also ones that we've already covered related to the financial issues. Count 4, the first-degree murder of J.J. Vallow. Again, we have ample evidence that a jury could use to reasonably conclude that the defendant is guilty of the murder of J.J. Vallow. In addition to the planning and preparation evidence that the jury would have heard related to the conspiracy that we've already covered, on September 23rd, the day after J.J. was last seen alive, witnesses testified at trial that they'd been staying with Lori Vallow, and that Lori told them that they not only saw Alex Cox with JJ, but that Lori then told them on the morning of the 23rd that JJ was with Alex. And the jury heard evidence about what Alex was doing that day because he was en route to the vicinity of the defendant's residence, and he was texting with the defendant that morning. Also, the jury had heard that JJ, according to the defendant, JJ was dark. We just heard evidence of that this very morning when the defendant was describing in text messages to Lori that JJ wasn't himself and that he was possessed by some type of dark entity. And like Tylee, JJ's body was found in a grave on the defendant's property. Again, ample evidence from which a reasonable jury could conclude that the defendant is guilty of the murder of J.J. Vallow. As to count 5, the conspiracy to commit the first-degree murder of Tammy Daybell. Again, the state alleged a series of overt acts and presented evidence on every single one of them. The first one, the espousing of religious beliefs, similar to the other two conspiracy-related charges. Evidence was submitted on that. Number two, again, we've already discussed that defendant's then mistress and co-conspirator Lori Vallow did move to Idaho, to where the defendant lived, another overt act. Count three, exchanging text messages regarding death percentages on July 30th. The jury did hear evidence of that. Overt acts 4 and 5, that the defendant and Alex Cox exchanged burner phones, that came into evidence as well. Overt act number 6, that the defendant's co-conspirator Lori Vallow exchanged texts regarding Tammy Daybell being possessed by dark spirits and being in limbo. The defendant and Lori Vallow were discussing that, and again, that evidence came in this very morning, Your Honor. Overt act number 7, that on September 8, the defendant signed an application along with Tammy to increase her life insurance policy to the maximum allowable under that policy. That came in via testimony and business records. Number 8, that the defendant's co-conspirator Alex Cox attempted to shoot Tammy Daybell. Evidence has been presented on that, Your Honor. Certainly it's been a source of contention in this trial and a source of cross-examination, vigorous cross-examination, but ample evidence has been presented that that is exactly what occurred. Overt act number 9, that Alex Cox did multiple internet searches related to that shooting. And number 10, that Alex Cox went to the firing range in preparation for that attempted shooting. Number 11, that Alex Cox drove to the from the Sportsman's Warehouse to the Daybell residence on the 9th of October of 2019. And number 12, that Alex Cox was near the Daybell residence on the 18th of October 2019 when Tammy Daybell died. All of those overt acts, the jury heard evidence on, and it would be more than reasonable for them to conclude that the defendant engaged in a conspiracy to kill Tammy Daybell. On count 6, the actual first-degree murder of Tammy Daybell, in addition to all of the preparation evidence that the jury heard related to the conspiracy, the defendant was telling numerous people in his life that Tammy was going to die soon. The jury heard evidence of that. They heard evidence that the defendant would send text messages to his mistress and co-conspirator Lori Vallow regarding how trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow, was shopping for wedding rings before Tammy even died. The defendant then told conflicting stories about how she died, when she died. At the defendant's funeral, Chad claimed that he had miraculously asked Tammy for all of her financial passwords just days before his death, or her death. After Tammy's death, Chad immediately moved out, cashed out Tammy's life insurance policy, and went to Hawaii to live with Lori Vallow, who he married just 2 weeks later. And of course, the jury heard evidence that Tammy Daybell's death was ultimately deemed homicide by asphyxia. Again, we have ample evidence from which a jury could conclude that the defendant is guilty of the murder of Tammy Daybell. As to the final 3 counts regarding the grand theft and the insurance fraud, there were There was a clerical issue. Thank you, Your Honor. As the final 2 counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion, but the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's husband, Charles, was killed by Alex Cox. In the immediate aftermath of that killing, Lori and the defendant exchanged text messages where Lori expressed her disappointment that she was not actually the beneficiary of Charles Vallow's life insurance policy. Then months later, not even months later, mere weeks later, the defendant goes with Tammy to increase one of her life insurance policies to the maximum allowable. And shortly after that, Tammy is killed. The jury has business records, they have testimony, they have ample evidence from which they could conclude that the defendant has committed the crimes of insurance fraud as to both the Primerica and LifeMap insurance policies. Thank you, Your Honor.
All right, thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that J.J. Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes. Why don't you, I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right, I'd note, there's actually a rule that governs this directly, Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against, and if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
All rise.
Okay, where are we at? What's going on? Somebody fill me in. Where are we at, guys? Let me scroll down. I am so hungry. My meeting just ended, but I need to know what's going on. I was just like, what's happening? What? Okay. What happened? I had a business meeting. I had a meeting. No. No. Come on. No. Can I rewind? Are you guys good if I rewind? No. What do you mean wrong dates for JJ's death? Okay. I'm going to breathe it out. Tell me where I need to rewind. Okay, so okay, but okay, hold on.
One,
Custody of JJ.
Do I need to deep breath this? No. Okay. Okay, hang on. This is okay. Okay, hang on.
All rise. District Court's again in session.
thank you. Please be seated.
My hands are sweating. My palms are sweating.
All right, at this time, we're back on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. The court will note that the state has rested its case in chief. At this time, then, I understand the defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges, specifically with Tylee and JJ. There is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges, and they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear that a motion for judgment of acquittal should only be granted when there is no evidence upon which to base a verdict of guilty. And that is from State versus Vargas, 100 Idaho 658. Essentially, the trial judge must review the evidence in the light most favorable to the state, recognizing full consideration must be given to the right of the jury to determine the credibility of witnesses. The jury gets to determine the weight of the evidence, as well as enjoying the right to draw all reasonable inferences from that evidence. And that's from State versus Huggins, 103 Idaho 422. Going through the charges in this case, Your Honor, first beginning with the conspiracy to commit the first-degree murder and grand theft by deception related to Tylee Ryan. The state charged a series of overt acts, and the state has presented evidence on all of those overt acts. Number one being that the defendant endorsed and espoused beliefs designed to justify the homicide of Tylee Ryan. Specifically, statements made about her being dark. These beliefs were part of the defendant's teachings, and it would be very reasonable for the jury to draw the inference that these beliefs that the defendant was espousing were designed to dehumanize these victims and justify their homicide. As to number two, that his co-conspirator Lori Vallow changed the deposit on Tylee Ryan's JP Morgan Chase account to her BBVA account. We also heard testimony from the state's financial witnesses to that effect. Evidence that his co-conspirator and then mistress, Lori Vallow, moved to Idaho with his other co-conspirator, Alex Cox, as well as JJ Vallow and Tylee Ryan. Multiple witnesses testified to this. We heard evidence that the defendant himself did Google searches for the wind direction on September 8th of 2019, the last day Tylee Ryan was seen alive, and the day prior to when the state presented evidence that Tylee Ryan would have been buried on the defendant's property. That is directly related to the defendant. Number five, Alex Cox went to co-conspirator Lori Vallow's apartment where Tylee Ryan lived in the early hours of 9/9. Certainly there was evidence presented to that effect. And of note, there was also evidence that the defendant was in communication with Alex Cox at that time, and that Alex Cox's phone was in the vicinity of the defendant's residence. As to number six, that Lori Vallow never contacted Social Security. There was also testimony presented to this effect. The jury also heard that just weeks prior to Tylee Ryan's death, that Lori and Chad was aware that she would still be getting those Social Security checks after the death of Charles Vallow, which does link the defendant to that co-conspirator's actions in never contacting Social Security. Additionally, the seventh overt act, that from September of 19 to January of 2020, Lori Vallow continued to collect those checks. And during a substantial portion of this time, Your Honor, the defendant was living with her in Hawaii and enjoying the proceeds of those checks, another reasonable inference that the jury could draw. As to the first-degree murder charge of Tylee Ryan, which is count 2, the jury heard evidence that the defendant claimed that Tylee Ryan was dark, that he was, again, exchanging text messages with Alex Cox the day after she was last seen alive, that Alex Cox was in the vicinity of his residence. The jury heard evidence that the defendant texted his wife the morning of September 9, claiming that he had shot a raccoon and burnt some limbs. And then Tylee Ryan's burnt and dismembered remains were found on the defendant's property. Her DNA found on the defendant's shovel and the defendant's pickaxe in the defendant's shed. So I think there's ample evidence on that count, Your Honor, and I think that does not merit even consideration of a judgment of acquittal. As to count 3, I won't rehash all the overt acts because there is some overlap with the count 3. conspiracy to commit first-degree murder of J.J. Vallow. The first overt act we've already discussed, which is the evidence of those espoused religious beliefs justifying the homicide of J.J. Vallow. Number two, we've already covered that the defendant's co-conspirator and then mistress, Lori, moved to Idaho with the children and with Alex Cox. Overt act number three, the jury heard evidence that Alex Cox, the defendant's co-conspirator, took custody of J.J. Vallow. As to count, or overt act number four, that co-conspirator, Lori Vallow, provided false information to law enforcement regarding JJ's whereabouts. We did hear testimony of that as well. Number 5 and 6, again, those are also ones that we've already covered related to the financial issues. Count 4, the first-degree murder of J.J. Vallow. Again, we have ample evidence that a jury could use to reasonably conclude that the defendant is guilty of the murder of J.J. Vallow. In addition to the planning and preparation evidence that the jury would have heard related to the conspiracy that we've already covered, on September 23rd, the day after J.J. was last seen alive, witnesses testified at trial that they'd been staying with Lori Vallow, and that Lori told them that they not only saw Alex Cox with JJ, but that Lori then told them on the morning of the 23rd that JJ was with Alex. And the jury heard evidence about what Alex was doing that day because he was en route to the vicinity of the defendant's residence, and he was texting with the defendant that morning. Also, the jury had heard that JJ, according to the defendant, JJ was dark. We just heard evidence of that this very morning when the defendant was describing in text messages to Lori that JJ wasn't himself and that he was possessed by some type of dark entity. And like Tylee, JJ's body was found in a grave on the defendant's property. Again, ample evidence from which a reasonable jury could conclude that the defendant is guilty of the murder of J.J. Vallow. As to count 5, the conspiracy to commit the first-degree murder of Tammy Daybell. Again, the state alleged a series of overt acts and presented evidence on every single one of them. The first one, the espousing of religious beliefs, similar to the other two conspiracy-related charges. Evidence was submitted on that. Number 2, again, we've already discussed that defendant's then mistress and co-conspirator Lori Vallow did move to Idaho to where the defendant lived, another overt act. Count 3, exchanging text messages regarding death percentages on July 30th. The jury did hear evidence of that. Overt acts 4 and 5, that the defendant and Alex Cox exchanged burner phones. That came into evidence as well. Overt act number 6, that the defendant's co-conspirator, Lori Vallow, exchanged texts regarding Tammy Daybell being possessed by dark spirits and being in limbo. The defendant and Lori Vallow were discussing that. And again, that evidence came in this very morning, Your Honor. Overt act number 7, that on September 8, the defendant signed an application along with Tammy to increase her life insurance policy to the maximum allowable under that policy. That came in via testimony and business records. Number 8, that the defendant's co-conspirator, Alex Cox, attempted to shoot Tammy Daybell. Evidence has been presented on that, Your Honor. Certainly, it's been a source of contention in this trial and a source of cross-examination, vigorous cross-examination, but ample evidence has been presented that that is exactly what occurred. Overt act number 9, that Alex Cox did multiple internet searches related to that shooting. And number 10, that Alex Cox went to the firing range in preparation for that attempted shooting. Number 11, that Alex Cox drove to from the Sportsman's Warehouse to the Daybell residence on the 9th of October of 2019. And number 12, that Alex Cox was near the Daybell residence on the 18th of October 2019 when Tammy Daybell died. All of those overt acts, the jury heard evidence on, and it would be more than reasonable for them to conclude that the defendant engaged in a conspiracy to kill Tammy Daybell. On count 6, the actual first-degree murder of Tammy Daybell, in addition to all of the preparation evidence that the jury heard related to the conspiracy, The defendant was telling numerous people in his life that Tammy was going to die soon. The jury heard evidence of that. They heard evidence that the defendant would send text messages to his mistress and co-conspirator Lori Vallow regarding how trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow, was shopping for wedding rings before Tammy even died. The defendant then told conflicting stories about how she died, when she died. At the defendant's funeral, Chad claimed that he had miraculously asked Tammy for all of her financial passwords just days before his death, or her death. After Tammy's death, Chad immediately moved out, cashed out Tammy's life insurance policy, and went to Hawaii to live with Lori Vallow, who he married just 2 weeks later. And of course, the jury heard evidence that Tammy Daybell's death was ultimately deemed homicide by asphyxia. Again, we have ample evidence from which a jury could conclude that the defendant is guilty of the murder of Tammy Daybell. As to the final 3 counts regarding the grand theft and the insurance fraud, there were pardon? Pardon? There was a clerical issue. Thank you, Your Honor. As the final 2 counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion, but the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's husband, Charles, was killed by Alex Cox. In the immediate aftermath of that killing, Lori and the defendant exchanged text messages where Lori expressed her disappointment that she was not actually the beneficiary of Charles Vallow's life insurance policy. Then months later, not even months later, mere weeks later, the defendant goes with Tammy to increase one of her life insurance policies to the maximum allowable. And shortly after that, Tammy is killed. The jury has business records, they have testimony, they have ample evidence from which they could conclude that the defendant has committed the crimes of insurance fraud as to both the Primerica and LifeMap insurance policies. Thank you, Your Honor.
All right, thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that J.J. Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes. Why don't you, I did say a lot there.
Of
and
course you
Mr.
do, John.
Pryor offered the state a chance to respond. Any
Flip
response
off.
from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right. I'd note there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial.
Hang on.
In terms of the time.
Hang on. I'm rewinding that 1 sec.
The accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right. I'd note there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against. And if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
All rise.
I don't even know what to say right now. I don't even know what to say. Like, who brought that to his attention? Did the judge? Okay, I'm going to read what Diana says here. Title 19, Chapter 4 indictment, 14 indictment. Court has discretion to allow the state to amend an individual template at any time. The state just can't add charges. Read the comment. Okay, so let's just go over this for a sec. The original charging agreement was May 25th, 2021. It had the correct date of 22nd to 23rd for JJ. It was amended in February of 2024. Now, Matt says if there wasn't a chance to fix this, there would be no 2-hour break. So who did the amendment? State just can't add charges, but can amend clerical errors at any time. But the judge read out 7E criminal code that they may permit amendment at any time before the prosecution rests. So why is that brought up right now? What prompted that to bring up right now? I understand that it is brought up right now, but why today? Why not yesterday? Why not a week before? Who brought this up? How did this happen? I don't know. And you know what? John and his little smug little comment, this is a dead little boy. So he should shut his mouth. Now, I did see Lindsay with her hands over her mouth. The judge found it, but why today? What prompted today? Who brought it up? How if he found it, why today? And why today after they rested? Okay. Recap. There was a motion after the defense, after the prosecution rested. There's a motion that there was an error on an amended indictment in February of 2024. The original document was, the charging agreement was May 25th, 2021, listed all the charges for Chad. And then there was an amended indictment in February of 2024 that changed the date to the 8th and 9th day of 2019, which contradicts that JJ it says that that was JJ's date, only they screwed up because that was Tylee's date. So JJ was alive on that date, which is a problem. And then the judge also has a problem with some language of on or about or on and between. And he says, according to the 7E Idaho Criminal Code, it says it may permit amendment at any time before the prosecution rests. And it just so happens to be that the prosecution rested today. And this is when the judge found it. I have questions. Yeah, only before resting, at any time before the prosecution rests. So it's amended, the original was correct. It was amended after that date. But the judge caught it after they rested. So what's going on? Right? Because I think what I left for my meeting, that they rested. Yeah, because I even wrote it down. They rested at 11:37. The defense rests. So what's going on? Of course the judge has to follow the law, but I'm curious why he would find out now. What prompted him to look at it right now after they rested? I'm curious. So whoever amended it in February of 2024, 4 months ago. Susanna says, Linda, I sent some things to you. Okay, hang on. I don't even know where my freaking phone is. Okay, right here. So they're coming back at 2:30. Woosa, woosa. I do not see anything. Hang on. No, I don't see anything yet. This is not good. It's a little confusing too, right? Yeah, Lindsay had a sidebar, but she had a sidebar before they rested. She had a sidebar before they rested because the judge says, okay, are you going to rest? And she says, could I have a sidebar? Then went to the sidebar, then came back and said the prosecution rests. At 11:37. Okay, judge did not find it. And someone's saying judge found it today. So I don't know what's what. John brought it up. Oh yeah, because he wanted the motion. Okay, so hang on. In 1 hour, they're going to come back. In 1 hour, they're going to come back. And we'll see what happens. They wanted till Monday, but they're going to go today. So we'll wait. We'll wait till that. Okay, so judge did not find it. There you go. Yeah, so John waited to the very bitter end, and that's probably why he was asking about dates the whole entire time. Remember, I kept saying, you know, like, oh, there comes the date again. There comes the date again. God, that guy. You know what the worst part is? Okay, good for him. He's going to feel good about finding this if it's in fact him that found it. Good for him. But at the end of the day, there's a little boy that's dead. And it was in Chad's yard. So we'll see if it can be fixed or what, but he did read out loud. This is the important and worrisome part. He wrote that according to 7E Idaho Criminal Code, they may be permitted to amend at any time before the prosecution rests. The prosecution rested at 11:37. This happened after the prosecution rested. So what the hell's going on? This is another, okay, so if they can't correct it, why did the judge give them 2 hours? How did he word it? Find their argument or something? I wonder what their options are. Well, that's the weird thing. He literally read out loud that they can't before, unless this was given a heads up before. But he's saying it's not, so I don't know. So they're doing something. Otherwise, why give the hours to do that, right? Let's go back. I'm just going to go back since we have some time. Hang on. Let's hear what he says. Just get that wording. Okay, why isn't it? It's not finding it now. Let's just go back for a sec. Oh, God.
Jury could draw. As to the ones that the
Only does not support a
Okay, let's
goes
read
with
what he
Tammy
says.
to increase one of her life insurance policies to the maximum allowable, which they have defendant insurance policy.
The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the
Prosecution
court
closed.
finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that J.J. Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yeah,
Yes.
of course.
Why don't
you
you,
do.
I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right, I'd note there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against. And if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on.
Okay, so they get 2 hours to prepare for additional argument. So there's a chance we got to be positive, right? We got to be positive that this isn't a giant nightmare. But basically, if you're just joining, there was an amendment made in February of 2024 on the 20th. And the dates of JJ's death was amended to the wrong dates. And this has been brought to the court's attention. And there was a 7E Idaho Criminal Code brought up that before the prosecution rest, they may permit an amendment of the actual indictment. But he's giving them 2 hours to prepare for an argument. So we'll see what that happens. We'll go from there. This is not good on that part. So they amended JJ's the charge on JJ. They changed it from the 22/23rd to the 8th or 9th, which is incorrect because the 8th/9th is Tylee Ryan, not JJ Vallow. So it was amended for some reason in February. So they amended the dates, and that's where they're in trouble. So they have 2 hours to prepare for an argument, but it's really less than 1 hour. We're going to be 45 minutes and we'll have that. Now I'm just going to fast forward to make sure that I'm up to date on the live. There we go. So we're just going to wait to see what happens. And we're going to put it out there that everything's going to be okay. Because I know that's not good. But they also have 2 hours to rebut. So to save their butts, basically. So we're going to put the good juju out there that this is going to be fixed and it's going to be okay. That's what we're going to hope for. Yeah, it's amended. Why would they? And the charge is count 4, first-degree murder of JJ. That they didn't screw up they changed, they amended the dates to that. So at 2:30, they're going to address the error. I'm going to put on here, down here, court back at 2:30 p.m. And I'm going to put a bunch of giant blue hearts for JJ. That comes up. Maybe the blue heart doesn't. Oh, yes, it does. Right there. This is not good. So, what I don't like, okay, even there's an error, we have to deal with the error. The worst part is John's smug behavior. He should be just as, like, good for you, you who cares? At the end of the day, his attitude sucks. And either way you look at it, there's a little boy who's dead and he didn't deserve to die. And none of them did. And so he can stop with his attitude and beat it. But the prosecution has 2 hours to figure this out. They have less than 45 minutes now to figure this out. They'll come back. They'll make the argument. We'll see what happens. And we also have Judge Boyce up there. And Judge Boyce has been, he's been fair. He's been fair. And he was fair at Lori's. So let me just pull this in. Hang on, and I'll save the image. May indictment. Why they did that, I'll never know. February indictment. I wish I would have saw that indictment. I would have said, like, I would have said something. Anyway, I didn't see it. Okay. Why now? Okay, so here's the original, okay? One sec. Here is the original back in 2021. Okay, you see at the top there? The defendants, Chad Guy Daybell and Lori Noreen Vallow, on or between the 22nd and 23rd day of September 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan or continuing criminal transaction between Madison, blah, blah, blah. Okay, first degree murder. And I'll take this comment out if I can here. Okay. At the very bottom, did either kill JJ Vallow and or assist? So that is correct between the 22nd and the 23rd. And this is the languaging that he was talking about before, on or about or on or between. He brought that as an issue as well. Okay, so then if we pull in the other one, so take a good look at that. And now I'm going to pull in the new one that was just amended in this February, 3 years later. Okay, here's what it shows. It shows the 8th and 9th, which is incorrect. It's incorrect. The correct one should say 22 and 23rd, which is like the original, which is this one. So that's where the issue is. So there's 4 very smart people on the prosecution, and they have time. So the judge can still make this okay, is what I'm thinking. They have time to come back, and we'll just see. And then we'll breathe this is the original right now. The original indictment is right on the screen. Okay, and then if I switch, I'm switching right now. This is the 2024 amendment, which is incorrect. Now we go back here. This is the correct one. Okay, so we're just going to put it out there that everything's going to be fine. It's going to be fine. Everything's going to be okay. They're going to come back. We're going to be okay. Now, I don't know what else was amended on that yet. If it was just that, I don't know yet. We're going to be okay. So that was on the charge 4, which is first degree murder for JJ. So I'm going to look to see. I wonder if I have that in my. Hang on, guys. I'm going to just see what was going on at that time. See if I can pull up if we knew of a hearing that day or what happened or around there. Okay. February 17th, state rejecting Chad Daybell's request to postpone trial. Is this around the time where he wanted to get out of it? Yeah. So on February 20th, 2024, which is the same day this amendment happened, it was a pre-trial conference for Chad Daybell. And they were saying they were both going to be ready for April 1st. The defense attorney, John Pryor, withdrew the previous motion filed on January 30th. Remember when he wanted more time? So that would have been the same day they had court. They had a hearing that day. And judge announced that day as well that the court had an order that it would be live streamed. And Lindsay, okay, here we go. Fremont County Prosecutor Lindsay Blake told the court that the state filed an amended complaint 2 days ago. Pryor said he had no plans to raise any challenge to the amendment indictment. But that, yeah, is not good. It's okay though. I am going to keep hopeful. I'm keeping hopeful that everything's going to be fine. They're going to come back in 40 minutes. They're going to state their argument. The judge is going to take it upon consideration. We're going to put it out this in the universe that the judge is going to take their argument. Everything's going to be fine. Okay, let's just do that. It'll be okay. That's what we're gonna put our foot down and we're gonna say everything's gonna be fine. Okay? So now I'm gonna be back in 5 minutes. I have not eaten yet. I'm just gonna go down 5 minutes, just wolf something down, and I'll be back in 5. And then we still have a half an hour to go. Okay? So everybody woo-saw it out. Woo-saw, we'll be fine. Yes, a little self-care, woo-saw. We're gonna be okay. They're gonna find, we're good. We're putting it out there. They're smart. There's 4 smart, amazing people on the prosecution. They'll have their tears. They've already gone through their tears, and now it's gonna be okay. They're gonna collect themselves. They're gonna come back. We're good. Okay? Woo-saw. Be right back. I'm starving. All right, I'm back. Here's what I think. Okay. Okay, this is what I think. And this is what I'm going to encourage everybody to believe and hope for in the next 25 minutes. Okay. We are going to put it out there that this is all meant for a reason. And maybe this little heads up or little scare, we're going to call it a scare, maybe it'll be a little warning for the prosecution to do their due diligence in the next couple weeks, double check everything or whatever they need to do. I don't know. But there's 4 incredibly intelligent, passionate, justice-driven people who are on the prosecution. And they are advocating for the victims. Was there an error? Yes. But I'm going to choose to believe that 4 intelligent, wonderful people who are on the prosecution have spent the last hour and a half and they're on the countdown to coming back and they're going to figure something out. Then I'm also going to believe that we have Judge Boyce, who, yes, it's brought up, but Judge Boyce has been fair. Judge Boyce is going to listen to what they have to say. And I find it incredibly hard to believe that this is going to this charge will be acquitted. Okay, so we're gonna put it out there, and it's gonna be okay. I think in the grand scheme of things, if we have this overall, it's just gonna show that they need to double check everything on everything. That's what I'm gonna choose to believe. Hang on, get my cat out because she's gonna drive me nuts. Go, go, go. Okay. So this is what I've been thinking about for the 10, 15 minutes I was eating. That we're gonna be okay. They're gonna be okay. The charge is still gonna stick. There's something that's gonna come up. I don't know what happened for them, and this is what I'm gonna believe. Because the alternative is ridiculous. So we can't even go there. Okay? Everybody in agreement, say heck yeah. You know what? I'm gonna get out the heck yeah. This is what we're going to put out the good juju. This is because I refuse to believe the other part. So let me get into my live stream and I'm gonna put the heck yeah out there. Here we go. And that's just the way it's gonna be. And the justice. We're gonna do justice right there. It's not a good mistake. I'm definitely not I'm not minimizing the mistake, but I want to minimize our reaction to it. Let's just say it that way. Okay? I don't know why it was amended. I don't know what happened. We're just going to be okay. Yeah, look at all the heck yes. There we go. And some hearts for JJ. Because there's no way, okay? In 4.5 years, it cannot be down to that. We'll be okay. I mean, even if you just take one person, you take Lindsay Blake and how she has asked these questions and she's thought of every detail. She's going to come in. It'll be okay. This is what I'm going to put out there. We're going to put that good juju out. Okay, so if you're just joining, what happened this morning is there's a major error, a clerical error on the indictment. And JJ's Chad's first-degree murder charge for the murder of JJ was amended. There was dates amended, and they were wrong. The dates were amended from the correct dates of the 22nd to the 23rd, and they amended it to the 8th to the 9th, which is incorrect. And that was amended in February of 2024, which is a giant no-no. I don't know what happened. The narcissist guide says the court will typically assess whether correcting the error impacts the defendant's ability. The court will typically assess whether correcting the error impacts the defendant's ability to defend themselves. Yeah, it's just a date amendment. So we're going to hope for the best. Yes. So we're just going to bring it down. Just bring it on back down. It's going to be okay. Yeah, we're going to send the good vibes. It's going to be okay. The only thing that was there's a lot of confusion, but what was confusing was when the judge brought up this 7E Idaho Criminal Code that it says they may permit an amendment of the indictment at any time before the prosecution rests. And I wrote down, which is so funny that I actually wrote down the exact time, but this morning I wrote down at 11:37 a.m. the state officially rested. So there's that. And for those of you just joining, John was smug as you know what. The F word. And that I don't find right. He could be happy in a certain way internally that they made an error and, but the smug commenting or the smug inflection in his voice didn't need to be there. So we're okay. Okay, let's just breathe it out. We'll keep it light. And then we can watch the reaction of John when the judge continues on or however that's going to work. And, we're going to learn. Carl. I don't know if I've ever said it on the channel. Have I? I don't think so. I might have bleeped it once. But now we can we'll watch John's face go from smug and smirky to the opposite. So let's just revel in that. Let's marinate. As Melly Plowski says, we're going to marinate on that. They should be coming back at 2:30. I did change my chiropractic appointment, so I don't have to leave. Yeah, we're going to just woo-saw, right? You guys had to woo-saw while I went and got some food. We're okay. Okay, maybe we need to get our mind off of it for a bit. It is the same time. It's 2:16 p.m. in Idaho. What was that? Hang on, guys. I'll be right back. Okay. I think there's going to be a little bit of smudging going on tonight. Okay. No, it was I have okay, don't freak out, okay? I have a mirror. I know I told you about the mirror story the other day. I have a mirror that you put like keys on, and it's not hung up yet. It's just at near the front door. But weird because it's in the corner of where my shoe closet is. And so I went to go look, and it fell down, but it's been there for quite a bit. So I might be smudging a little bit after. Okay. I wonder what I said right before that. Do you guys remember? I know this. My heart rate now. I was just talking about this the other night. Smudging is like I guess you take sage and you go around the house, and it's like a spiritual practice, I want to say, with the indigenous, perhaps. Hopefully I said that. Is that the proper right word, or is it now First Nations? I'm not too sure. You guys know, let me know. So I don't want to say it wrong. But you go around and you can get rid of the bad juju around the house. Okay, we're just going to breathe it out. We have 11 more minutes. I think I was saying to change I think what I was talking about last is to change the subject, didn't I? Do we have any questions? Do I still have snow in Calgary? No, but it's May long weekend coming up, and we usually get snow. Yes, you may. I would love to do a meet and greet. Okay. No, but hang on. Not okay, and will not be. We can't have false hope. That's what cults teach. Okay, but this isn't about the cults. This is just about, let's just simmer down and calm down. And in 9 minutes, we're going to see what the argument is about, and we'll breathe it out, and then we'll see what they say. And then we can go from there. Okay, we just breathe. Okay. I hope though it's going to be on time because we don't want to wait, right? Where are we at in the, let's talk about the like button. Let's just let's keep it light for a minute. Okay. If you haven't done so already, let's click the like button. Let's give some good juju out there. Don't stress out. That's right. Don't stress out. Everyone breathe in together. And breathe out. Yeah, they should be back at 2:30, hopefully. Hopefully it won't be too late. I mean, unless they need a few minutes. And we just learn another thing, right? We learn another thing about trials, and hopefully I would like to see Chad's face be not so smug, and also John Pryor. Oh, now we got flashing of the, did you see that? It flashed? Okay, we're okay. Okay. Yes, this is beautiful. Christiane says, the fact that Boyce is giving them an opportunity to respond gives me hope. Yes. 6 minutes. There's going to be some major self-care tonight if that doesn't go well, but we're going to put it. She is very smart. There's 4 smart people on the prosecution. We're going to be okay. Thank you. No need for the eyebrow fund, though, right? We should be having a lemon drop martini right about now. Like, my God, we've been putting in the work for how long? 6 weeks watching this, 4.5 years going through it. There's no way. I'm going to just put it out there. We're going to be fine. Judge is going to be fine. The prosecution's going to give their argument. It's going to be fine. Now, I think actually now that I'm thinking, okay, give me a moment. I gotta think of this here. It's been a while, so I need a moment. Talk amongst yourselves for a minute. Just looking up something, guys. One sec. So I'm just looking at what was happening around the time in February when that amended indictment. So the amended indictment happened on February 20th. And on the same day, there was an affidavit return of service, subpoena issued, and then the status conference on the 21st. Hmm. One minute. We're only talking about count 4 for JJ. Me too. We'll be okay. We're just gonna put it out there. Man, we're gonna need a nap after this. Where was that? Oh, I hope it's gonna pull up. Can we go back to the simpler times of the lawyer drunk filing? Remember that? Remember that day? Now, on positive news, remember in the beginning, I think it was during jury selection, there was chitter chatter about Arizona. There was something that had to do with Arizona. And the documents, I think, were sealed. There's something going on with that. So maybe Chad's going to be heading to Arizona later. Let's just put it out there too.
Seated.
Here we go. He's on time. Fingers crossed.
All right, good afternoon. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from the case State versus Taylor, 157, Idaho, 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, reviewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29, starting then with the counts that I am prepared to rule on. On count one, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim Tylee Ryan was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis, also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion. And count two, the judgment of acquittal motion is denied. Moving next to count three, conspiracy to commit first-degree murder of J.J. Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau. That the overt acts, again, were testified to by witnesses including Zulema Pastenes, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those seven, actually six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count 4, as I mentioned. On count 5, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenes, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count 1, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count 2, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count 3, Nick Edwards. Count 4, Nicole Heidemann. Count 5, Nick Balance. Count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first-degree murder count, as it relates to J.J. Vallow and the issue the court brought up. So, Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
Right, I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be, because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count for jury instruction, which is very similar to what the court in Jones did, and as we'll discuss in a moment. Third and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to count the date within count 4 as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from, quote, month, unquote, to, quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of J.J. Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, J.J. Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And in Idaho Supreme Court's case, State versus Jones dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial or between the information and the jury instructions only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend or was left open to the risk of double jeopardy, unquote.
I do have a question about variance.
Yes.
Because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
question.
Thank you, Your Honor. So that would be the states, and I understand that, I certainly understand the complexities that this course of action presents to the state, but there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here, and I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beatty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point, after the state has rested, is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now, he pled not, or excuse me, guilty, not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on this short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244 that talks about Idaho Code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right. Looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at Criminal Rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment, and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, on that, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment. They made the allegations. They're stuck with their indictment.
All right, counsel, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling.
Organized.
Oh dear. Okay, so there's one of the things that I liked about, there's one of the things that caught my ear that Ingrid Beatty talked about was the date that it was already known to the defendant. I thought that was pretty smart that she brought that up. That was at the beginning of her argument. And that the date is not the element of the crime. So she was trying to back that up. And she said that the date was already known to the defense. And for 2.5 years or whatever. And that it was already known. I thought that was an interesting angle of how she took it. Or how she argued it. Some of it's hard to understand because this is the first time I'm hearing some of this, right? However, the other part is that John has an equal point because even the judge stated it earlier today about Idaho Criminal Code 7E that they may permit the amendment of the indictment at any time before the prosecution rests, and the prosecution rested at 11:37 a.m. So John has a good point. I hate to say that, but he does. So, but I will say that in 2 hours, the prosecution, I mean, I don't know. I think this has some weight to it about this already known to the defendant, this date. She said 2.5 years and the entirety, the counsel and defendant are aware of this date since May 25th, the 21. And it was that date. So I like that. I don't know what kind of weight that is with the judge, but I think that's a good point. Like I said, this date is not an element of a crime, is what she said. So that to me is I thought that was strong. I don't know if the judge is going to feel that way, but I feel that's strong. And I'm curious to know, though, Is there a more official way of resting? I guess I need to know that. Because saying they rested is official and it's on the date, or is there an actual something on top of that? I don't know that. The other thing is Pryor kept talking about December. He kept saying something about the December, and it wasn't. This is an amendment that was made in February. Because I guess my thought was, okay, earlier I said the defense rested, or the prosecution rested at 11:37, and then I thought, well, I wonder if they do that like by the end of the day because there's nothing else. But that can't be right because the defense could potentially start that same day, right? Right. It's on record. Okay. So I just wonder, well, wait a minute, maybe it's when court's done that the official, but it makes sense from what we were saying. So what I originally said earlier, we'll go with that. Okay, but I do like, there's some things that Ingrid had some good points on. I'm going to say that. And I'm not just saying that because they're the prosecution. I think she made some decent points. Maybe some of them were a little bit grayer, but I do like a couple. And she brought up a couple interesting angles. With John, he made a good point too. I would have fought that too. It's like, nope, this is the rule. This is the rule. Forget about the rest. This is the rule. I would have said the same thing. And she said they can reopen the case. That's the other thing. That's right. And John says, well, they don't have a right to go back prior to resting the case. They've already rested the case. He talked about wiggle room. And this was interesting the way he was like, and the four lawyers. Remember in the jury selection, he said the same thing. It was like, not the same things, but yeah, those lawyers or something like that. And Lindsay actually brought it up the next day saying something to the effect of like, stop talking, calling us that. So this count is count number 4, and it's first-degree murder for JJ. This is count 4. So everything else is fine. We got a problem with count 4. So this is the one in question, is count 4. Yeah, he did say that, didn't he? I heard that. Did he say tip? Wasn't going to tip them. He said something like that. Court is not done for today. We're waiting for Boyce to come back. He's taking a little bit of a break to figure some stuff out and then come back. Because we just heard the prosecution argue and fight for their life, pretty much. So in February, they amended the indictment, and it was the wrong. I'll show you. So here is the original indictment. First-degree murder, count 4. And it's the 22nd, between the 22nd and 23rd day of September 2019, which is the correct date, it was correct. Notice it was May 25th, 2021. But in February of this year, so just 2 months ago, 3 months ago, it on the 20th of February, how the heck that's been 3 months, I'll never know. They changed it, a clerical error, from the 8th and 9th of September, which is incorrect. So this is what they're fighting about, which is a major thing, but they're fighting about it. And the prosecution is saying it was a clerical error, and then they're like, for 2.5 years, it was right. How do I get this off? For 2.5 years or 3 years, it was right, and this isn't. And they're trying to say that the date is not an element of a crime. She says, I know it sounds counterintuitive, but, and then she pleaded her case, and then she said, the dates were already known to the defendant for that duration. So she's minimizing it that way. I thought that was a clever and interesting angle. She does make a point, and it sounds like she came from the Windsor case she was talking about. I think that had to do with, that one was the Windsor case. I was trying to write as fast as I possibly can. So we'll see what the judge says. He's got an interesting decision to make too. And then we see John Pryor come in, and he made a good point. He just said, what makes it stronger is because the judge said it too, right? Like, no, Idaho Criminal Code 7E, you don't have a right to go back. It's specific, and it specifically says they don't have a right to go back. And that, he made a point. Now, did he have to tug those 4 lawyers? You had 4 lawyers. I can't remember what the judge said when he's coming back. I'm not sure. Looks like the short day's not so short. It'll be okay. I'm just gonna. He didn't specify time. Okay. So we're here. We're here, and we're gonna see this through. Judge went to the bar for lemon. Oh, lemon drop martini. So good. And I barely drink, just to let you know that. But lemon drop martini I did have on Mother's Day at dinner. And my son took myself and my little boy, my oldest son, bought us dinner at a fancy little restaurant. It was quite nice. Very sweet. Okay, hang on. Where are we? Shoot, where did that go? I saw the 7E. Where did it go? 7E doesn't apply to amending clerical errors. Our 1914-20 applies to clerical errors. This is stressful. I know, this is so hard. All the other counts, that's right. All the other counts are good. Sufficient evidence on all of them. So take that, John. Yoga Cat says, do multiple witnesses testify JJ's pass away date? That's another pro. Yeah, there was lots of confirmation of dates that I remember. Lots. Because they did timelines and all that. Thank you. And she made that point too. The original was the 21st or the 22nd and 20th. The original was correct. It was 2.5 years. Chad knew the dates for that long. And so did John. So let's hope that Boyce just weighs it out and says, I took some time. Here's what I have, and here's how I feel. I did catch that, and then I saw that the prosecution tipped their head up, and then he changed and said David Warwick and Melanie Gibb. I did catch that. Lawyer says this isn't a big deal and judge will change it. Great. What? I'm doing what I can, Rebecca. Some of this is all brand new to me too, so I'm trying. Yeah, remember I was saying that earlier. Remember how adamant he was about the dates and stuff, but he didn't bring it up. So I don't know, but he did say something to effect that he wasn't about to tip his hat or something like that. I can't remember. Okay, thank you. It's like, I gotta stretch. My chiro appointment was supposed to be in 10 minutes, but that's okay. I pushed it tonight. I pushed it. And I got some editing to do, but that's okay. This is very, very important. And we're all together. All 2,700 of us are together in this. So we'll see. He'll come back. The judge is going to go do he's going to think about it. He's going to pull up some stuff. Like he said, he's always pretty good about that. He comes back. Let's just reflect for a moment, though. Let's get some happy thoughts about when he basically told Pryor about what kind of ridiculous things that Pryor was doing when he tried to get off the case, but not really, because I think he was trying to manipulate. And John was like, and Judge Boyce was like, yeah, no, you're gonna fight this. You're in it. You can't get out of this trial. We're at the 11th hour. Thank you, Rebecca. Thank you. Thanks for all being here, you guys. And then, you know what? If we need a little comic relief, there. Let's be happy for a minute, okay? Okay? Can we just take a moment and just smile for a moment? Let's lighten it. Okay, let's just lighten the load for a minute, lighten the mood. And this is who we're dealing with. Okay? So let's just chill out for a moment. and enjoy. And then let's see if I have the spaghetti. You know, like let's take a moment and reflect and marinate on what's been happening throughout time. Okay? This is just breathe it out. We're going to have faith. Remember when the judge, we got to go back to the raccoon for a minute. Found the raccoon. Found him. I found him. We found it. Where's the raspberry bush? Okay, there. Do we feel better? We got to feel better. Thank you, Stitchin is the best. Thank you for gifting that. And thank you, Sue Olson, as well. Thank you. Okay, there. Do we feel a little bit better? Okay, that's going to get our spirits a little higher. We found him. Oh, Your Honor, I found the raccoon. I found him. Oh, I have an even better picture of Chad. Hang on. Let's see if I have him in here. I do put this a lot because I feel like I need to expose his dumb look. Oh, I do. Here we go. Let's just breathe it out. There he is. There. Just to give a little bit of fun. Okay, so it's going to be okay. The judge is going to come back. Remember. Okay, let's put this too. Okay, good. Good. Lacey, thank you, Linda, for all your hard work. You're welcome. Thank you guys for being here. Thank you. Marlene, the judge is trying to find a legal way to void the amendment and make original indictment ruling over. I think so too. We're going to be okay. Okay, but let's rewind for a minute. Do you remember in Lori Daybell's trial? Do you remember how much people were so worried, me included? We were going through like, I don't know if this is going to be like, what's going to happen. And at the very end, the judge gave a tongue lashing to Lori. In fact, maybe we should bring that up. Let's see. Maybe we bring that up and we could watch it. What do you think? Do you think that would make us feel a little bit better? Because he gave a tongue lashing. Yes, thank you. Found it. Okay, we're going to be okay. We found the raccoon and we found the raspberry bushes. Let's see if I could just find not so long clip. Okay, hang on. Email alert. We needed a laugh today anyways, right? Oh, we have more. Oh, yes, I've seen this. We did the, okay, hang on. I'm gonna. This was our other laugh the other day. And we had another good meme too. It had to do with the bing and all the stuff sticking to the this. Okay, we just need to chill out. Everything's gonna be okay. It's hard not to be worried, though. I understand that. Okay, let's see if I can find. Might take a moment. Hmm. Sorry, guys, for not talking. Just one sec. Might be a while that he does it. I'm just trying to pull it up first for a second. Okay, so he is addressing her. Now, do you want it? The only thing is I don't know if I want to bring that in here because we're waiting on this court. But if you guys are okay with listening to it, and then you just have to stare at me. But maybe you could still hear it, then we'll be okay. Are you okay with that? I'll turn it up, make sure that's turned up. Let's see what he says. This is to Lori. Okay, hang on. Sorry, I just thought about this that this might get confused with it being actual. How about that if I put the banner across? Because that might get confusing. What do you think? Oh, you can't hear the sound. Weird. You couldn't hear the judge talk? Okay, we'll wait. We'll wait. Maybe what we'll do is, let me take this off. Maybe I'll see if it was written and give you the good parts of it. Because basically the judge told Lori that she's an idiot. Okay, you're going to hear typing. One sec. It's hard because sometimes I'm trying to pull it up and it brings up recent stuff. Oh, he says this. You chose the most evil and destructive path possible. Despite having a wealth of better, less harmful options, Boyce told Daybell. Okay, blah, blah, blah. The judge noted the disgust he saw on the jurors' faces during the trial. The scene was horrific. Yeah. Oh, they didn't say too much of his. He basically told her she's gross. Like, she is a pathetic mother is what I got from it. So. It's going to be okay. Thank you, Mel, for the super sticker. Thank you. And welcome aboard, Deb. Yeah, he did give her a public lashing. I wish I would have seen the... Wish there was a transcript. I think out of all the last few weeks, I think the prosecution has done a pretty great job. And maybe out of all those days, I'll give John maybe 2. Really, out of all of them. And that's not me just because I don't like him. It's just, I think, maybe 2 days, 3 maximum. Today was kind of a win for him so far. So the judge is going to note it. I mean, wouldn't that be shameful all on just that date? Although wrong, it is wrong. But I did like how Ingrid Beatty found that angle. That's smart. Ian says all of Pryor's arguments where he mispronounced should not count. Oh, they're back.
Thank you.
Guys,
Please be
here we
seated.
go. Here we go.
All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the courts considered those arguments, and at this time will make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on Criminal Rule 29, which is for a judgment of acquittal. I already indicated the standard in the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court, having considered the arguments of the state and the defense, I'm going to rule as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state, by motion in November of 2023, sought to amend the indictment, and the court went back and reviewed that motion to amend the indictment, and specifically leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023, granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of J.J. Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things that I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving J.J. Vallow as a victim, and he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of J.J. Vallow in this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court, having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I have also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard, so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It's not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that, but for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All rise.
Well, well, well. Boom. So we can breathe it out. We're going to give ourselves some self-care. And this is great news. Yeah, I have the throat. I have the little lump in my throat too, you guys. So it was kind of scary. No court tomorrow. They're going to let the defense pick out a new pack of diapers for Monday for both of them. Denied. Spud's McSpaghetti. Thank you. This is awesome, you guys. My cheeks hurt now. I got the he's getting the new pack of diapers out. Oh, that was stressful. That was stressful. And the judge went with that history of the date and the it shouldn't have been amended. Thank goodness. You're welcome. See, we have to be a little positive, right? Whew. Everybody breathe out. It's going to be okay. It's good. No court tomorrow. We're going to go on Monday. We're going to breathe it out. We need a day of reflection. Thank you to Judge Boyce. Absolutely. Imagine him going back. He's like, I have to figure this out. What do I got to do? You know, what do I need to do? Let's see what happened. Thank God it was something that it was not supposed to be, because it would have been terrible if it was supposed to be amended. But why would it be for that date, right? So defense starts on Monday. Somebody was saying they're eating marshmallows. Oh, sure. After I've eaten half a bag of mini marshmallows. You know what? When I went to go grab some food an hour ago or whatever it was, I thought to myself, I need chocolate. I need some good chocolate right now. I need chocolate. And I don't have any chocolate in the house. I might have to go get myself some before I go to Cairo. Yeah, the prosecution. Who did you see Lindsay? She literally was like this and putting her eyes up, and she's closing her eyes and just doing one of those. Whew. Yes, absolutely. Whew, that must have been a rough couple hours for them. Not good. Oh, thank you, Carmen. I'm gonna go get a chocolate. I'm gonna wash it down with a chai tea latte with oat milk. Oh, and I'm gonna get chocolate. A lot of chocolate. Feels like Friday. They did do an amazing job in 2 hours. Imagine that stress. Imagine the stress. You're given 2 hours to fight. And so you're going back there and pulling whatever you can. I wonder if they have a bunch of people helping. You see, we all need some chocolate. Whew. Martini, chocolate, whatever. Was he behind me? Was it yesterday or today that I started talking and then Charles came? I finished saying every time I talk about something important, Charles comes up, and then he came up right away. Going through YouTube, and lots of YouTubers are using clickbait saying prosecution incompetence might cause an acquittal. Yeah, I know. I wait to get my facts and then talk about it. That was yesterday? Wow, you see? It's been like 6 weeks in a row. I honestly, when I think about April 1st starting this, it feels so weird to me to think about that. It feels so weird. Do you guys have the chocolate bar in the States? Do you have Big Turk down there? That is so good if you put it in the fridge and then you eat it. It's very good. You don't have Arrow bar though, I don't think, down there, and Arrow's amazing too. Thank you, Texas. I do my best for sure. No, you don't have that? It's like it's like a chocolate covered jujube, but like a big chocolate bar. Hi, Debbie. Nice to see you. Thank you. You too. Thank you. And Arrow bar has bubbles in them. Those are really good. I don't know what a toffee symphony bar is. There's need essential oils. Oh, that was rough. You know what's good too? Do you guys have Milk Duds? You get popcorn, okay? Movie popcorn. You get movie popcorn and you get Milk Duds, and you pop both at the same time and chew them, and it's like caramel popcorn. It's amazing. I go straight for the chocolate when I get stressed out for sure. Reinvention 2 says, this was my first time on this chat and it was super fun yet frustrating too. I know. Thanks for being here. Thank you, all of you, for being here. Oh, Henry's, they make them in Canada. We get that. Coffee Crisp is so good too. I can't eat them anymore because I had to go gluten-free in 2006. So, oh my gosh, that was a long time ago. It's 18 years ago. That's crazy. And I loved Coffee Crisp, was delicious. Wow, what a day. What a day. Dentists love Milk Duds. I bet. You put them together. You just put like the Milk Duds with the popcorn, the buttered popcorn together, and it's so good. You guys know all about chocolate because you guys have to do it too. I guess as I go get a little bit older, I like salt too, so I like some chips, but I don't eat junk very often. Otherwise, I would gain weight quite quickly. I know that was rough today. I mean, it feels like an extra long day too, and I guess probably because our nerves are shot. Today is day 25, so if we even go back, this morning was Doug Hart on the stand. And we had the little bit piece of information that on June 9th, when the kids were found, the authorities tried to talk to Chad's kids. And they agreed initially, but then they backed off once they talked to Chad and they declined to speak to them. And that doesn't feel like this morning. That feels like a couple days ago, to be honest. And then I read out all those text messages this morning. And then, of course, his just grabbed me by the storm comment, and John objected. Lots of that. And then we went into this crazy bit because we were supposed to be done early. And we went through this motion of acquittal, and this uproar. Well, thank God it was the right answer, because it would have been bad. So crazy. While all of this was going on, the nurse came in and said, "Your blood pressure is sky high. You need to calm down." I said, "I can't calm down." I kept telling her stupid prior. She was laughing. Who saw you guys? Will you see a new video? Yes. Well, I recorded a video this morning. Now I'm gonna go and try to edit it for a few hours. Then I got to go to my chiro and try and get my back fixed. So you'll get it either, I want to say tomorrow for sure. Tonight's going to be iffy. Depends if my how I do, because I also have my editor, but I haven't given her the heads up about it. And she's on a movie set right now. So we have 3 days to mentally prepare ourselves for the lies that will be told on Monday. Isn't that the truth, Abby? Thank you. That's very true. Now, this will be interesting too, because John's been amping up his behavior. And so now today was a little bit of a kick in the teeth for him, because he was getting excited about it. So we'll see what happens next week. He might just double down on his jackassery. Raccoon hats all around on sentencing day in court. Thank you. Oh, okay. Whew. Deborah says, dark chocolate. We need dark chocolate on more of our existing Canadian chocolate bars. Yes, thank you for your hard work on this case and others. Let us see you next week. Keep up your self-care. Thank you, Deborah. I appreciate that. Thank you. Oh, well, we could always do a homemade nut bar. When will I do another live? Well, for sure, Monday will be a live for the court. I'll be doing a members live. I just gotta schedule that out. And I'll be finishing up my video that needs to go out. So that'll be within today, tomorrow. I want to say tomorrow, because today I thought I was going to be done by, 1 o'clock kind of thing. And so it would give me more hours, but it takes probably about 4 hours to edit a video that's 20 minutes long. And I would love to have my editor actually look at it. So I think I'll just do the preliminary stuff and give it to her, and then we could get it for tomorrow. Toffee bars, yum. No pressure, Linda. The last 2 hours were very stressful. You don't need another cortisol spike. I know, I've been cortisol spiking all day. I'm sure you guys too. Yeah, he's gonna be jackass in the jackassery. Oh yes, we do. Coffee crisp and ketchup potato chips. And all dressed chips. I think it was 2 Christmases ago, maybe it was 3 now, when I was still with my ex-husband, his family all came up. I basically kept it a secret because his sister wanted to surprise him. So they all came up. There's like 14 people in my house. And I bought the kids, so my ex-husband's nephew and niece, I bought them like things that you can't find in the States, with the chocolate bars and the candy, and they were loving it. Ketchup chips are so good. When I was pregnant with my first baby, I was craving ketchup everything, and I even put like ketchup flavoring on popcorn. That was when I was pregnant. That's so sweet, Susanna. Well, I hope everything goes well with that. But I got a bunch of nurses loving Linda. You guys are awesome. Kim, that's funny because the same baby, the same son, like oldest son, he wanted or I wanted Kentucky Fried Chicken and I refused to eat it for 10 months because I was pregnant for 42 and a half weeks. Went into labor early, they stopped it, and then 42 and a half weeks. But the last week, I sat in one sitting and ate a whole bucket of chicken. Coffee crisp chocolate bars are so good. It's been so long. All I do is now I just smell it. Kiara says, I generally would have been crying all night if it got dropped. Yeah, I would have too. As soon as I came, because I had to go to a meeting. I had a meeting and I came back and everybody's just going, oh, like all hell was breaking loose. I was like, what's going on? And then we re-watched it together and then it was not good. And then worry for how long? All right, Jill. I hope they create a cure for enemas. the anemia / enema of John Pryor and how it's not curable. Darby says I wanted pineapple shakes every day. My second kid was oranges and oranges. I couldn't get enough of oranges or fruit. Dark chocolate's so good. Thank you, Beth. Thanks for the super sticker. I appreciate that. Where you been, Siobhan? Enema the steak got flushed today. We don't know who's on the defense list. I know Chad's kids. No, we're not. So everything's okay. The judge basically said that it was a clerical error. It wasn't supposed to be changed. And so we're okay. And he said also that there's sufficient evidence also in terms of JJ. So all Chad's counts have sufficient evidence. So there's no acquittal. He just basically beat it. Clerical error, we're good. Oh wow, yeah, fresh fruit was my craving. My younger son was like that 20-pound watermelon. Oh, and my first son, I ate a full flat of cherries in one sitting. I gained 55 pounds with both of my children. I was a big girl. Oh, wine gums are so good. You know, my sister steals the red and purple wine gums and she gives me the green and yellow. I was like, what? Why are you so mean to me? Cherries. It's the dark cherries too. So good. I'm so happy that Judge Boyce said no acquittal as well. And then when I was pregnant with my youngest, I made my ex-husband and me, we went and tried to find gluten-free apple pie, and we went to like 5 stores and couldn't find any, and I was crying. I was legit crying because we couldn't find any. I just went to 5 stores. Like, all I wanted was an apple pie. we gonna be okay? We're totally gonna be okay. um, isn't it crazy that cravings is so weird? Arrows are in Canada, so I don't know if they're yeah, they're in Canada. They're really good. Like little bubbles in them. You all are evil with the chocolate stuff. Bing cherries, yes. That's what they are. They're Bing cherries. Chad won't again. No, hang on. What kind of fruit does he get? Because he does get fruit. Okay, let's see what his dinner is going to be today. Besides Pryor's spaghetti. He must be so angry. Oh, guys. Okay. Let me find it. I love you guys. I really do. You're great. This is the amount of, this was just, see how long I've been scrolling? That's literally just half a day's worth of emails. I guess I'll be doing emails all weekend. Oh my gosh, I don't know. There we go. Let's see what's on for dinner today. So I think it might be week 2 for him. And it's Thursday. So he gets a hot dog. A hot dog with baked, or is it Franks and beans? Frank's, it says bun, fruit, mustard, ketchup. Yeah, I'm thinking a hot dog. Onions, baked beans, veggie sticks, ranch, and relish. That's what it looks like he's getting today. He's ours on a plate. Holy toast? You're very welcome. Defense starts on Monday. More than he deserves. That's exactly it. His scam sandwich. Yeah, for lunch he had today. So fruit is for his snack. He would have got a peanut butter jam sandwich today, is Thursday, right? Peanut butter jam sandwich with veggie sticks and potato chips. And this morning he would have eaten cream of wheat with pumpkin bread and no pork sausage. I don't know. Oh, I have the somebody sent me the document. Tomorrow he gets oatmeal banana pancakes with syrup. His snack is always fresh fruit. And then for lunch he'll have a deli meat sandwich with tortilla chips and a cookie. And then tomorrow evening, he'll have ham and cheese packet, whatever that is. Oh, maybe ham and cheese pocket with rice and 3-bean salad, fruit, and a cake or brownie. That is the jail dinner. Yeah. And Saturday, he gets lasagna. Yeah, pumpkin bread, it says. No loin fire, apparently. Me too. Yes, Maui girl. Yeah. They basically said that it was the judge said it was a clerical error and it wasn't even supposed to be amended to that. So we're good. Everything's okay. You're welcome, Karen. Thank you guys for being here and for watching my videos. Without you guys, there wouldn't be this channel. So yeah, still exhaling. Prison smeat. Sex, power, and money spam. I love that. I think that was thunder. Court is done for the week. We are going to be back on Monday, which gives me a lot of time tomorrow to sort through a bunch of info and get some good videos out for you guys. You're welcome. No storm. Sorry. It was thunder. I think it was pretty sure that was thunder. Yeah. Yes, garden. That's awesome. I just did a teeny tiny bit on the weekend. I had to up level my front little garden. I didn't buy any flowers though, because May long weekend it always snows, so I'm not gonna do that. Thank you, Tim. You know, what a week. Zaluma. I'm glad you had a great time. Yeah. I do need to smudge a little bit. Maybe I get to breathe out a little bit on the weekend too, but it looks like there's going to be some possibly great things coming to the channel. So I had a really great meeting today, so we'll see what happens. And I'm doing my best to bring you guys great videos. Oh, that's very nice. Thank you. It's very nice. Thank you. I love it here though. I love, we have to keep up the live streams. Now, Will you guys be joining me in June for the preliminary hearing of Corey Richards? Because I'm going to be back here. We still have John to go with his witnesses. Now, just a word of warning though on John, okay? Remember in the beginning where there was like we went all day on just John talking? I think it's going to be like that again. Mark my words. I think with his witness, it's going to be all dang day. So it might take a long time. He was on fire. Hey, Jeremy, nice to see you. I haven't seen you in a while. Where are you? Where did I see that? I see you, Jeremy. Where there you are. Yeah, so they mixed the dates. There was a clerical error. It ended up being a clerical error. The original indictment was okay, but in February there was a clerical error made. And so it wasn't supposed to be made. So we're good. It was a little stressful the last couple hours. I'm so glad, you guys. Yes, many people say, Linda, listen, Linda, listen. I don't know who else will be on the witness list. I'm not sure. I am going to be excited, though, for a short time to go back to the gym. I'm going to say that. I love your videos, but man, your timelines are top notch. I always think to myself, let me go check out Linda's timeline. Yes, you're going to see more of that. You will see more of those. I need to see it too. In my mind is like, no, let's look at the timeline. Let's figure this out. I know. I just, I took that minute. I went downstairs to get myself some food. I went, no, unacceptable. We're going to sit down. We're going to look at it positively. Oh, yeah. It's going to be long. Like, it's going to be long-winded, right? Yes, Linda Spin. Well, I'll have to dive in, and maybe now that it's gearing up, how long do you think it's going to take for the defense? Well, it's John. It's going to be longer winded than Lori's. It has to be. I wonder how long that's going to be. Timeline of would that be fair? Oh, yes. It's so true. He loved his timelines. Yeah, timelines are where it's at. The truth is in the details, as I always say. You think only 6? You guys think less than 2 weeks? I think it's going to go long-winded. Maybe 2 weeks. You guys are all around 1 to 2 weeks. Some are saying long 4 weeks. Okay, now it's raining, so that definitely was thunder. Yes, big day today. One person on the stand's going to take all day because John's going to want to talk about every single thing. Think about this. When we've heard John, he goes off the rails a little bit because he wants to divert, right? So it's going to be very interesting. 1, 2, 1. It's going to take a long time. And John's going to ask everyone about Melanie. Oh, I didn't even know you got that. You got called a troll. I'm so sorry. That would definitely, in my mind, would never be even a question. See, positive juju out there. I sat down like, no, this is what we're going to do. This is going to go to the universe. This is how it's going to be. And see, it was good. I know you guys don't want to watch them. We'll see what I'm going to go to the Cairo tonight at 7, and hopefully he can calm my back down a little bit. So if that's the case, and maybe next week will be a little bit better. Last week when I was in so much pain, it was so hard to concentrate and do any videos and all that. It was just like hard enough to get through the day. So we'll see how I feel. And then this weekend. So I'll start diving in and ripping some things apart. Harriet says, in opening, didn't JP say he had a forensic pathologist and DNA expert, forensic anthropologist, along with Chad's kids? Quite possibly. Good memory. Wow. That was a long time ago. I don't know if I remember that. I do remember him talking about the DNA because he kept saying over and over that there was a lot of evidence of hair. Do you guys hear that? I think it's going to hail. Oh, wow. Do you hear that? You guys have to hear that. That's hardcore. Yep, that's hail. Hail to Chad going to jail. Next on It's a Crime. There are tornado warnings by Hannah, Alberta. Really? Hannah, really? I'm apparently having a storm. No, I'm not having any storms these days. I would love to go to Ireland. Mm. Canada does get tornadoes, yes. I guess I also have to do the decoding video too, don't I? I have a couple things to do. And then I would like to do a different video on a different case. But we'll see. And the chair, yes, the chair. We got to narrow down the chair and the desk. I have so much to do. Yes, I saw the picture of Emma Blonde. I have it here. I think it's still loaded somewhere. Do I have it still loaded? Ooh, I might have taken it off. Everybody dyed their hair. Have there been any movement? No, I'm waiting any moment now for Barry to get arrested again. Lori said she wanted the contractor who quoted only 3% chance of trouble to get punched in the face. I have to re-listen to that. Yeah. Yeah, that it's bad. I keep feeling like I need to stretch it. And yesterday when I went to Cairo, they didn't I had to book Cairo again today because I went yesterday and they didn't really do a great job that time. Last time he did amazing, yesterday not so much. So I'm going to a different guy that I've been going to for years and years. I used to compete a long time ago in fitness contests, and I've been going to this guy for like 20, 25 years, 27 years. Oh my God. A long time, and he will dig in there for me. So I'm gonna go see him. Oh, my butt. There we go. Because I was recording this morning. That's why my mic is covering Charles. Chad's going to hail. Sue, the number 4 is all good. We're good. We're safe. Everything is safe. I love Charles too. Like I was saying, sometimes I come in here and go, "Hey, Charles, Lori's an idiot." And whenever I see Gannon come up, I go, "Hey, little buddy." I know I'm a little bit of a weirdo, but I do say hi to them. I did move my mic. Yep, they sure were. You're welcome, you guys. Thanks for being here. I'm going to go pretty quick too so that I could start to edit and then prep to go to my appointment. It's exciting times are coming. Let's just say that. Exciting times are coming to the channel. I'm excited. Think it's my time now. It's our time now. And yeah, he's always going to have a place in my heart. And I share the same birthday with his mommy. So thank you so much, you guys, for joining me. We'll be back on Monday morning. And stay tuned for videos. I hope you guys are going to get notifications. I might find a way around it. I might have to find a way around that you guys still get notifications of some sort. I don't know how yet, but hopefully you get them and then we'll just go from there. And yeah. I think your guys' comments are coming in a little bit late, so I'm a little confused where we're at. All right. Thank you so much. Thank you to the moderators. Thank you for your super chats. Thank you for hanging out with me and being in this in the trenches. I know it's been a stressful day. So be good to yourself. Go and do something nice for yourself, no matter how little, how big, but do something nice. I know I'm going to. I'm going to be mindful of that. So I love you very much. Stay tuned for the next video, and we are going to see justice. Don't worry. Bye. Love you.